patient today. I think some urgency there can be taken tomorrow. The concern on the other side level and accusation will.
Item 12, with the request of Mr. A. Roy. Matter is adjourned for 2 weeks. Have you taken consent of the other side?
Yeah, I have taken the consent of that.
It is submitted that consent of the respondents. Counsels have also been taken. Okay.
There is an interim order that will be.
The interim order, if any, will continue to the next 6 weeks. Let it come after vacation then. It will come after vacation.
But actually, they have given consent for 1 week.
1 week. Then let it be on 27 June. 27 June.
No, please. But I beg to mention item number 52, supplemental engagement.
Yes.
It may be taken as 2.
Right.
52.
Why 2?
I have another put number 1, item number 6 or something.
You, this is a fresh matter.
Fresh matter.
You will call for CD. Why 2? You asked one of your existing counsels to be available here. We cannot guarantee you at 2. If you want it in the second half, it will be taken up in the second half, but not at 2. That we cannot guarantee you at this moment.
All right. May I please? Item number
6.
Right.
Yes.
Item number 59 of
How can I forget? I'll give you the number of the case. What is the case number?
Case number is DA number 2029 of 2023. That along with DA number 1557.
No. This number I know. What is the other number?
Item number, this code is item number 6 and check along with item number 59 of code number 7.
What is that case number?
Okay, that case number is 1557 of 2023.
It is submitted by counsel for the petitioner that this matter be listed along with 1557 of 2023. List after a week.
No, my today is fixed. That item.
That I cannot send it from here to there. That I cannot do it. You can take a pass over. Let the matter be passed over at the request of learned counsel for the parties. You take it up with the registry. I cannot send the matter from here to this court.
Then the will be taken from this court.
Huh?
We
We are passing it over today. You attend to that court matter first. All right. 6 passport. 22. What has not been received? Diary. You are on interim.
No, my.
Yes, case diary. When can you get it?
Can it be on 23rd?
23rd. 23rd. Item 22 list on 23rd at the request of learned counsels for the parties. Matter learned APP to produce CD on that date.
I calculate for criminal appeal law. Probably on Thursday, it is permitted to sit on level 4. Allot this appellant hearing is in date for last more than 4 months. Allot the appeal is pending.
Let it
Thursday,
Thursday, be
any date for this one.
let it be on 23rd.
So I recommend for listing on criminal appeal for final hearing.
Finally, it will come for orders list on 23.
Services formula there is a
Let it be on 23.
20 lakhs.
20 not possible. 23rd. 23rd.
23rd is a difficult one because here is
Then let it be listed after vacations. No. 26.
Senior counsel BD4 on the will appear.
26.
Not available on the
26.
20 or 19 lakhs.
20 or 19 is difficult. There are so many matters fixed. So many matters fixed. We can give you on 26 if you want. 26, 27, take it in. Yes.
Departmental for listing of the criminal petition. Day after tomorrow, my lord, 15 is next, airport, my lord.
Day after tomorrow.
With due respect, Lordship, I beg to mention I simplified supplementary list, Lordship,
Yes.
wherefore withdrawal, Lordship.
You are Mr. Doctor.
Hey, Dr. Yes, Lordship.
At the request of Mr. A. Doctor, learned counsel to the petitioner. The paid petition is dismissed on withdrawal. It is submitted that he has been instructed to withdraw the matter by the petition. CD, if received, shall be returned. Interim bail, if any, stands withdrawn.
Okay, by that, the mention for a listing of one regular relativity and the connected sale of it, which is the today, sorry, in item number 24. In this case, 6% corrected and 4% already granted bail.
Have you filed the bail? Have you filed it?
Will file on Friday.
Friday.
Because this matter may take any of the item 24.
Unlisted is not permissible. You do 24, this matter will be listed on Friday. Wednesday. A fresh matter on Wednesday. If you want to do 24, who's appearing for 24?
Otherwise, the city will go low.
Who's appearing for 24?
They are here. His name is shown in the.
You be available on at item 24. We can, if the councils agree, we can fix it for day after.
The item number 28. It was all for it was not available. List after vacation.
CD not available, list after vacation. It is submitted that the petitioner is on interim bail will continue. List again on 17 August.
Interim contract.
Interim continues.
Lordship, I am saying for a listing of a criminal appeal where I interpret a petition is also there, Lordship, for bail of a petitioner. Lordship, the petitioner on 10th, yes, on 10th, 6/2023 is kept in ventilation at GMCH. So, madam, can be taken as tomorrow, Lordship. This condition is not so good, Lordship.
Tomorrow,
Yes, Lordship.
can it not be on day after? Day
Is
after.
in ventilation, Lordship, from 10th.
All right, tomorrow.
Okay.
I can put 39 lots. I'm the above this. So he is not well lot. So we can make password for the day. 39.
Item 39 is the request of Mr.
It is only
A. Sharma, learned counsel, appearing, mentioning on behalf of Mr. J.C. Bora. Stands adjourned. It is submitted that learned counsel appearing for the petitioner is indisposed to be. List after 1 week. After 1 week. Any CD received? LCM. Okay. All right, list after a week.
May I please, Lordship? Lordship, I beg to mention item number 27 and 38. May I be kindly responsible for the payment?
27 and 38. At the request of
My lord, in 27, I have interim method. And CD
your name,
R. Bora.
MS RR Bora, learned counsel, appearing for the petitioner. In 2027,
Yes, sir.
submits that the matter be adjourned for the week.
Lordship, petitioner is not interim.
It is in the interim. You have the CD.
No, Lordship. CD
Not available.
not available.
All right, then let it be listed on 17th August.
Lordship,
Interim order to continue. What about 38?
38, no, madam, 30, 30.
30.
Lordship, CD is available.
CD is available.
No.
So are they connected matters?
Alright.
Are they arising from the same PS case?
No, madam.
Different.
Yes, sir.
So,
Ask for the payment of time. Yes.
all right, item 30 is next week. List on 20.
Lordship,
CD receive the retained in the next day.
Offline.
Lordship, I like to mention item 26. It is not available. Another time,
26,
It is not available.
CD is not available.
Lordship, interim order regarding the review.
At least on 17 August, interim for CD. CD, only CD or injury report?
Only CD lordship.
Only CD. On 17th August for CD. Meanwhile, interim pay granted will continue in the next week.
Very good.
Yes. Mr. A. Conical Learned Counsel for the petitioner submits that the parties have settled the matter amicably outside court, and therefore he has instructions that the petitioner does not wish to press the matter any further. The criminal revision petition accordingly stands dismissed on as not pressed. The LCA call for is returned, interim order if any is removed.
May I please, Lord, I recommend the committee for listing of criminal petition law. For hearing. Lord.
For hearing.
Yes, Lord. Madam, we take it. Next week, any day.
Next week, any date, 22nd.
All right.
The lordship has the paper title number 85 members. Other than paying for an adjournment in this matter, matter of the episode was also and Twitter has informed me, episode is not received.
You're on interim. You're on interim. Well, then let it be on 21st August.
Lordship.
Polling for CD as well as FSL report.
Lordship, CD is available otherwise.
Right, you retain the
That will
CD.
be sent.
CD. Huh?
That will be sent by copy.
Then we can have it in July if you can.
Lordship.
24th July.
24. Okay.
One for FSL and CDB retained.
Lordship.
Petition as interim to continue.
I mean,
Yes, yes, interim will continue.
Then in this motion B, item 1.
You were registered in connection with this. On 16/3/2020. And as such completed 87 days,
Hmm?
and there is 3 days remaining to be completed 90 days. Left.
Then let it come on
Thursday, Lordship.
Thursday.
Yes.
Let it be on Thursday. At the request of the council. List on Thursday.
Item 2.
Hmm?
15/1.
Yes, 1/5. 1/5.
Item number 2.
Yes.
What the was arrested on 28/4/2023 euro. As on today, 46 days completed. What the was arrested in connection with kilometer PSQ number 83.
Where is your FIR?
FIR is a page of it. 9 euro, so this is a translated copy of it. Can read it.
Yeah, let's call for the CD.
Lordship.
Third learned council for the parties, call for CD. Sila Kotak, when get you get it? List on
Lordship,
23rd,
24th. Along with 164 and medical.
along with 164 and medical report. 23rd June.
Item 3.
Yes, Mr. Chaudhary.
Four 39 application, arrested, so arrested on 19/4 madam. 55 days in custody. Apparently, older madam. Police madam,
60-day offense.
19 madam.
90.
60 days.
Is it 60 or 90? 353,
326 in there.
326.
Another case is my lord, prior to this affair. Same day, another affair was there. He was already arrested in that case. That case is fixed on my lord 28. Can it be on 28, both the cases, my lord?
20.
20.
All right. With the request of learned counsel to the party to discuss this matter on 2006, along with
Along with my lord, BA 1968.
BA 1968. 23.
No.
BA 1968 of 2023.
Along with injury report.
Yellow waiting gentlemen.
Item 4,
Senior counsel issuing another part one finding.
We call for CD. Right, learned counsel to the parties. Call for CD. This is coming from document
Yes. On 26
26.
of lordship.
Alright, this was 26 too.
26.
item 5,
Yes, please, remember. I thought you will find it page 11.
Yes.
Okay, that's second. Yeah. Page 11 is the.
Yes.
Yes.
Page 11, Mary.
Yes.
This
Yes.
is to inform you that an information has been received from reliable source that the following person, namely one, Aladdin son of Satantas, Jehud Islam Satantas, Abdul Razak son of Satantas, Abdul Shahid, and others under Bangalore OP area have been dealing with high Indian currency in Bangalore other area. In this regard, BPA DD number Satantas status 23/5/2023. Accordingly, I along with BC, Producer Pregu and UBC, WPC, Bajanti Theory, and 113 women staff, and about to put the above mentioned person, but found nothing, any currency not during search. On investigation, the above mentioned person considers that they are along with others, namely one Muhammad Zakir Hussain, registered petitioner number 2, and number 2, Muhammad Atikul Islam. Some of and my lord, can explain my lord. A group making fact Indian currency note and fact gold like composite statement of business price, fact gold book. After introduction, the accused Muhammad Mizanur Ahmed Rahman leaded the police team, and I along with staff conducted raid in the house of Muhammad Mustafizur Rahman, Mizanur Rahman, Sabir Hussain, and Muhammad Sahabul Islam, and recovered monitor 2 numbers, laptop 1, UPS 1, CPU 3 numbers of printer, 5 numbers of 5 numbers, and accordingly, this is the thing which were used for fake Indian currency note. From the accused matter, the accused matter, nothing has been recovered from any of the accused matter. Actual matter, some of the printer and others was recovered from matter on the general Rahman matter. Super petitioner are concerned matter. They were earlier when the charged with similar type of offense matter, and proper prisoner number is the one is concerned matter. He was acquitted in that case matter. I have another copy of that matter. And so from the prisoner number 2 is concerned matter, he was also earlier charged with similar type of offense matter, and therefore matter police matter called the petitioner the police station, and as on when matter prisoner matter appeared before the police matter, they were taken into custody and matter sent to the jail matter. And so far, my prisoner number 1 is concerned matter, let them matter, CD may be called for matter, but so far prisoner number 2 is concerned matter. He is a patient of, he is a cancer patient matter. And earlier occasion matter in the other case, earlier case, while the prisoner has filed a plea before this another court matter, and considering his matter, measure of vigilance, seriousness of his condition matter, he was allowed to release on bail matter. May I take your lordship to the matter, the order matter at page 31 matter. Page 31 matter, he was earlier charged matter. Page 31 and relevant is at page 32 matter, third program matter. Page 32, today while pressing the bail prayer matter, and pressing bail prayer petitioner had submitted many documents to show that he has been suffering from cancer. The medical documents disclose the prisoner cannot eat solid food. I am satisfied with the prisoner in suffering from cancer in serious manner. Considering the fact, only I have doubted whether he would survive in judicial custody, and the prayer for bail is allowed by. And page 33 onwards, the release motion also matter. I have another some of these medical documents matter from page 33 onwards matter. It's from since 2016 matter.
He'll get all medical help in the custody.
And I'm in custody matter.
Yes, so all medical help necessary. Is he not getting it?
Because my cancer patient.
No, is he not getting any help? What treatment does it require?
In jail matter, to some extent, I am getting, so far matter, the cancer is concerned matter. In jail matter, that facility is not there. And on the ground, and as on date, matter already 18 days in custody, and nothing has been recovered from the prisoner for so long. He was arrested on matter 25 differences. And present only for matter, prisoner number.
Let us call for CD first.
Lordship.
Let us call for CD.
Similar matters are fixed on 26/6.
26/6.
Lordship. I can.
Arising out of the same FIR.
Same.
Item number?
4, today's list.
We'll keep it on 26. Let procure this.
Only for the prisoner number 2, matter, only on the ground of matter, his bail condition. So for prisoner number 1 is matter, concerned matter, 26 matter, it will be alright. But so for prisoner number is 2 is matter, already 18 days in custody. For any condition.
No, condition all right, but let us have a look at what is the investigation carried on similar matter.
FIR itself also it appears matter.
No, FIR is the first information, report. You know that. Every detail about the case will obviously not be written there.
I will cooperate with the investigation about
Quite
18 days in custody.
Quite right, but the question is mainly on a submission. What is his status? What is his current status of health? Have you got any documents? Can we take us?
Since 2016 to
No, present status.
He is my standing in my jail.
That's all right, but you can,
He cannot take solid food also, madam.
you, madam, please get a status on his health.
No.
Get a status on his health
No.
and when can you get it?
Tomorrow is.
Tomorrow,
Or day after tomorrow.
day after tomorrow.
No.
Let it be on day after tomorrow. Learned APP is permitted to obtain current status on the health condition of the petitioner number 2. Who stated to be suffering from cancer. He is unable to take solid food. The proper medical report in respect of the status of the health condition, the petitioner number 2 be placed before this court on the next date fixed. Let the matter be listed on 14th. And who will certify his health condition? Jail doctor.
Jail. Superintendent of jail.
No, superintendent of jail is not a medical person. Some
Lordship, there is a, in fact, also the doctors are there. He used to give prescription.
list on 20, list on 15, sorry, 14. 14.
All right.
Supplementary list, motion via item 51.
Yes. Third level councils for proceeding. This one of charity.
Lordship,
It will be on 26.
36.
Order to give you. Motion. Not shown connected. What is shown as connected?
Item 52.
52 is adjourned.
Yeah, did it.
You wanted adjournment.
But this matter has already, I have to send one my colleague matter. Therefore, I.
You want to do the matter today? Yes.
Matter. Page application matter, FIR page number 9. Focus on respect from 366 AMI. Please take it maybe call for my LME 162.
Third level council departments, call for CD. Along with 164 and medical.
Maybe.
This is from Kamru,
On
based on. Any date, when 21st,
21st.
31st.
All right.
For motion item 7.
Investigative object, object 438 application, SI is registered under section 302 34 80. Dropping the petitioner number 1 is the brother-in-law of the husband of the deceased. And the petitioner number 2 is the elder brother of the husband of the deceased. Lordship, the FIR is the case number 12, Lordship. May I read out the Lordship? I respectfully inform you that nearly about 4 years ago, my niece Somiran Neta was married to Abu Saya, son of Mokshadali village, Puhutoli, Ambari, TSC Kaza, Dorong. After 2 years of marriage, the in-laws of my niece carried on mental and physical atrocities upon her. On last 21/4/2023 at morning, Azibor informed over phone, that is the petitioner number 2, that my niece Somiran Neta committed suicide by hanging herself at her home. On the same day, our family members appeared in the said place, and on questioning the local people, we came to know that Somiran Neta did not commit suicide. He was murdered by the below name accused and gave the color of suicide. We find our niece sleeping in the floor inside their house. Also, we did not find any mark of suicide by rope on her neck. This is the allegation
From the room. Yes, madam.
Have you seen along with the postmortem report?
Lordship, the petitioners are in no way involved in the arrest of her. The petitioner resides in a different place.
The procedural case doctor.
And ironically, Lordship, the husband of the deceased has not been implicated in the case. Only because of the fact, because there are informant lives in Gwalpara, Lordship, and the incident is of Dorong district. Now, only because of the fact, because few days back, the informant had a few exchange of words with the petitioner. So as soon as the incident happened, he came up with this frivolous allegation only after grand serve. Lordship, may kindly be pleased to protect the petitioner.
Where have you stated all that?
Para number 6, Lord. Para number 6.
Third, learned counsel for the parties. The petitioner, the plaintiff is in connection with because her PS case number 183, the section 20. So it is submitted that in a file dated 24/2023 was lodged by the informant one Kadam Ali, alleging that his niece had committed suicide on 21/4/2023 by hanging herself as informed by the petitioner number 2. Is alleged that the niece did not commit suicide, but the accused person named in the FIR committed murder and gave the color of suicide. When the informant went to the place of occurrence, she found the niece sleeping on the floor inside the house, and no mark of suicide by any rope on her neck, etc. was found. Most of the present heavy petition is filed. There are London APP submits that did CD, also PM report. In the meantime, if the petitioners are arrested, they shall be released on furnishing a bail bond of rupees 30,000 each with one local security or like amount. The satisfaction of the arresting authority, subject to the following conditions. Petitioners shall appear before the eye within 10 days of today and shall not hamper or temper evidence or influence any person or move out the jurisdiction of so and so police station without written permission of the eye. Based on 21st of August. Sorry. 21st of July.
Lordship, the PM report, detailed forensic is there.
They will get it.
I think we have like.
Please, your lordship. For the test, please. Lordship offers under 120 and 302, your lordship, and separate best to your
Yes.
এজাহার করে গোচৰৰ বিৱৰণ এই যে মিনাবড়ো মোৰ মাহি পায় 2-3-4-2023 তাৰিখ সময় আবেলি 4টামান বজাত মোৰ মাহি মিনাবড়ো ঘৰত সকলে আছিল আসামীজনে বলপূৰ্বকভাৱে মোৰ মাহিৰ ঘৰত প্ৰৱেশ কৰে আৰু মোৰ মাহি মিনাবড়োক হত্যা কৰে আৰু উক্ত ঠাইৰ পৰা পলায়ন কৰে
Let's call for the CD and PM report.
Lordship, petitioner name mentioned in FR 3, Lordship, PL number 3, Lordship. And petitioner was called by the police personnel of the corporate police station, and accordingly, a statement also recorded. And there,
Then why are we apprehending arrest?
yes, Lordship, but petition also allowed to return that.
Then why are we filing this AB petition?
Apprehension is the police personnel again.
Then we'll see, call for CD
Lordship.
along with PM report. Huh?
In the meantime,
No, in the meantime, you have been called, you have given a statement, where is the apprehension?
Lordship,
We'll see,
again.
let CD be called for along with PM report, placed in 26 June. June, 26 June.
9.
Court material application, madam, lordship will find the FIR at place statement.
Yes,
May I return, madam? My lord, with due respect, the humble submission of the informant is that on last so at around 9:30 PM of night, while my maternal uncle Asaraddin was going to the house of his relative brother named so from the house of one Dalal Putri. The accused person jointly, out of prior rivalry, in a pre-planned manner, resisted him and on the midway, with the intention to kill, assaulted him with sharp weapon like dagger, pala, etc. in their hand, caused injury on several parts of his body. The accused number 1 poked my maternal uncle with pala, intending to finish him, and accused number 2 stabbed with dagger on his head, causing injury, and due to heavy bleeding, he became unconscious. During the occurrence, my maternal uncle could identify the accused person in the moonlight. On his hue and cry, when the nearby people came, the accused person went away, and thus somehow his life was saved. Since the injury was severe, so immediately he was taken to the hospital for treatment. The photocopy of the doctor advised is annexed there. Delay in lodging the error is caused due to remaining busy in treatment of the injured. Here, my lord, is staying, my lord. The accused person, my lord, 1, 2, 3, 4, 5, my lord, all are before your lordship, my lord. But so far, accused number 1 is concerned, my lord, he is around 72 years, my lord. I annexed the voter ID, my lord. And number 2 is my lord, government servant, my lord. And number 4, my lord, he is a 83 years old person. That also, my lord, I have annexed the, my lord, the Aadhaar card, my lord, to show his age, my lord. It may be a case of 325, my lord, but all the persons were not involved in this. The whole family has been, my lord, roped in, my lord. And from the FIR, my lord, it's specifically stated, my lord, the accused number 1 and accused number 2.
So let us have CD along with medical
Yes.
and all right, except 1 and 2 will grant interview. In the meantime, if the petitioners 3, 4 and 5 are arrested, they shall be released on interim bail, punishing bail for rupees 30,000 each with 1 local security like amount subject to the following condition. We shall appear within 10 days. Will appear within 10 days. And it shall not influence or attempt to influence any person or hamper or tamper with any evidence and over jurisdiction of what is the police station? Mera Chel, Mera Char, Mera Char access without written permission of the IU. The prayers of anticipatory bail for petitioner 1 and 2 will be considered upon perusal of the city along with the injury report.
Can I before I my accused number 2, my the government servant. Is it teacher my
Specifically named. Yeah. Short date,
It's 26 months.
26,
I was there.
26.
Supplementary list for motion item 53.
The last one, CD was
Some status report,
I just.
status report, item 53.
Stated. Can it be up to some time?
For some time. Possible.
They've already intimated on 7th June itself.
It is not come.
Perhaps, let us verify after some.
Daily list for admission item 10.
Yes.
Hello there. The petition is first class alert that already issued a notice for assessment of the salary. On the which
Have you made payment?
The husband did not pay lordship, but there is a order, husband did not pay lordship. And he, in the meantime, retired from his service.
আমাদের দুই ডিপার্টমেন্ট অফিসার মানে ফটো কনসার্ন যেটা অফিস মানে ঠিক স্যালারি বলতে কি এরিয়ার মেইনটেনেন্স
All right.
It was fixed in the month of February. As per my information, no report was yet received by the report.
That is called the court to pass appropriate orders.
Right.
So matter should be admitted for hearing.
Lordship may give a short date, after 1 month, a date may be given. In the meantime, I will take a copy from the landed law court. Certified copy of order passed in the landed law court.
Our learned counsels for the parties. This court by the earlier order dated 24/5/2023 directed the petitioner to furnish proof of payment of maintenance to the respondent number 2 in compliance with the order dated 5/8/2022 passed by the court. Today, when the matter is listed, learned counsel to the petitioner has submitted copy of the order dated 18/1/2023. Whereby the Court of Judicial Magistrate First Class Kokrajhar directed attachment of salary of the petitioner not exceeding 2/3 of the salary per month till recovery of the area amount of rupees 3,44,000 and also towards payment on of the maintenance allowance of rupees 8,000. So, learned counsel for the respondent number. The respondent submits that she would like to obtain required instruction in the matter. And seeks a short date. Accordingly, let the matter be listed in the month of July.
Yeah.
19 July.
Yeah.
Enabling the parties to apprise the court regarding the payment of maintenance.
The monthly maintenance is not paid, Lordship. There is an only order.
The payment of maintenance as directed by this court by earlier notice. Based on 19 July.
Apply.
Item 11,
And the earlier order dated 24/5/2023, the order direct the petitioner to deposit 25% of the compensation amount before the rest date. According to the petitioner on 016/2023, he deposited the 1 lakh amount before the rest date, and additional affidavit is filed on 8/6. This is not in a product, this is not in record in the.
On that occasion, they had paid an amount of rupees 1 lakh to the registry. My lord has asked them to brought on record and the same is filed, my lord. My
Have
lord,
you received a copy?
yes, my lord, I have received the copy. That is true that they have filed, they have taken. My lord may take my.
No, we don't need your copy.
Yes, my lord.
It's not available here.
Let us raise the director being on record.
Hmm?
Let us raise the director being on record. Additional.
It is submitted by learned counsel for the petitioner, Mr.
This one,
B.
Islam.
Islam. That 25% of compensation amount as directed by the court was deposited before the registry of this court. And an affidavit to that extent, the affidavit to that effect has already been filed by the petitioner. Also, learned counsel appearing for the respondent does not dispute the contentions of the petitioner. However, copy of the affidavit stated to have been filed is not available on the court registry to trace out the affidavit stated to have been filed and connect it to the case records by the next date fixed. Based on 23rd.
item number 13,
Mr. Roshi, kindly the matter be possible for a time being.
Passed over for time being. For time being.
14,
My lord, I have been told in the early morning, my lord, that his senior is out of state and my. My lord, one thing may can be done, my. Record may be called for, my lord. In this case, my lord, and matter may be fixed for admission hearing. It is compiled finding, my. Can I at least, my. And he is in interim, my lord, and that may be continued subject to the payment of at least 20% of the awarded amount.
So many orders we can't pass. We can,
My.
if he wants, you are praying for an adjournment.
Yeah.
We can call for the records if you want. Any other orders we can pass it on the next date fix.
Record may be called for.
Third learned counsel for the parties. Learned counsel for the petitioner submits that the matter be deferred as the arguing counsel. Who's the counsel? Who's the counsel?
Yeah, Ahmed.
Mr. A. Ahmed is not available. And he seeks a short date. Six an adjournment. So learned counsel appearing for the respondent submits that the records we call for. Accordingly, let records connected to both the records are required. The records pertaining to criminal appeal, sorry, CR case number 74 of 2014. from the court of JMFC Hajo Kapu and criminal appeal number 05 of 2023 from the court of Session Judge Kamru Down be called for. Interim order passed earlier, will continue. Is there any interim order? There is no interim order. There is no interim order.
There is an IAM,
I. Yes, interim order passed in the IE Criminal 351 of 2023. By the order dated 4/5/2023 will continue. Till the next date fixed. List on. List on 27 June. Or let it be in July. List on 20 July. 20 July 20.
Can it be 21st?
21st, all right, 21st July.
Fine.
21st July.
Online.
Item number 13, I am told, the counsel for the petitioner, Mr. Das, his daughter is not well, he is in hospital. So he has an urgency because the order he has sent is fixed on 16th of June. So can it be tomorrow or day after, when it is convenient to the court?
Day after. Let it be on day after 14.
Problem.
Item number
13.
13.
13.
Day after tomorrow. At the request of the counsel for the bar.
Item 15.
None appears. Passed over already. As it for another PPA appears for the state. So, second.
Bail hearing PA, item number 16.
Is right, along with the postmortem report was called for that we have not received.
May I please object? For that, several times it was called. If we have a ticket not available. Then 74 days already behind the bar, my lord. And the mother of the petitioner is yes, very serious condition, my lord. From the petitioner is the only one person for good of harm. Age over 85 years, my lord. The mother of the petitioner.
Where is the FIR?
Case number 12, my lord. Unnamed FIR, my lord. May I read, my lord?
Where is the mother of the petitioner?
Letter to Muthra.
There it is. Then
There is no person for the victor of the matter. Only one on the matter with the British part of the.
why are you arrested in connection with this case? You are not named. Why were you arrested?
Hello, without doing someone, my lord, the police, I went to the house, my lord. And
Where
at the time of arrest, my
in
lord,
Mathura?
someone issued, my lord.
In Mathura?
No,
No, where were you arrested from?
who, my lord? That is Mathura, my lord.
Mathura.
Mathura, my lord.
Why were you arrested?
But in this case, in connection, my lord, on suspicion, my lord.
Should kindly come to page 19, forwarding.
I was at my own, my woman. Recently, came to my house, my lord, and arrested me. And at the time of arrest, my lord, someone was issued, my lord.
Router where is the page 20.
Very serious allegation.
Not sure,
You are the main subject.
not sure.
Why the CD has not come?
No, should kindly give us the shortage of.
We have been giving you several dates.
Not sure.
This quoted, my lord. In the connection, I will put it.
You call it
19 or 20,
19th,
not sure.
19th. Purely in the interest of justice, learned APP is granted further time to call for the CD along with the PM report. And statements of the witnesses if available. Also. In the event the ECB is not produced on the next date fixed, consequential directions may be issued by this court. Based on 19/6/2023, calling for CD. Mr. So S. Raman,
Yes, sir.
Learned Counsel appears for the petition.
Okay.
Based on 19.
17. Maybe. Today is the fourth day for production of the injury report.
Yes,
Already 54 days behind the my lord.
where is the FIR, please? FIR?
FIR, my lord. Is. Is 12, my lord.
CD is available.
Well, case there is available, because the injury report is not available. I have to go through.
Yes, what is there in the case diary?
My lord.
What is there in the case diary?
But other notes is from my lord, this particular is indicated, hopefully I'll go.
What is the stage of investigation?
My lord, it is pending for the injury report, okay, and
Injury report.
because the partial model, they were arrested, okay.
Injury report for the injured.
If you're okay.
Uh,
Because it is whether it is for the severe or minor.
So why such a long date? We call for the injury report immediately.
My lord,
Where is it coming from?
my lord, go to.
Then
My lord, as per the version in the FIR, the informant was treated as GMCH. And on the last occasion, it was also revealed that there is a discharge certificate in the city. So on the very date of the incident, she was also discharged. And as per allegation, there is injury in the head. 11 stitches were put. There is a seizure list also wherein a bamboo lathi was also seized, which also contains some blood stain.
No, they will be on further, we try to produce the.
My lord,
Otherwise,
enough time has been consumed by the prosecution side. Today is the fourth day. And even the same date she is treated in research, then why not the injury report has been collected? May cases of the date of 18/4.
you get it by tomorrow. Wati,
It will be day after tomorrow. And try to produce.
day after tomorrow.
Day after tomorrow, I have a problem. My brother-in-law, he died and Shraddha ceremony is there.
Then
Further,
Thursday.
or my lord, my junior friend also can appear, because only one for the injury report.
My lord, a lady, my lord. 4 days, kindly you was considered.
I think, oh, after the tomorrow,
54 days, my lord, a
Get
lady.
it by tomorrow.
my lord.
Get it, we'll keep it for tomorrow.
So all the personal appearance of the IO may be also given. Let him come and address this honorable court.
If not available, you bring him to court.
Yes, my
List the matter again tomorrow
colleagues.
for production of the injury report. As the same has not been produced in spite of several opportunities being granted to the petitioner. Sorry, to the state. That's learned ABP. Mr. Surenso appears for the petitioner. Mr. Surenso appears for the state. Tomorrow?
Tomorrow at 2 p.m.
Hey. All right. We are saying tomorrow.
Well,
You will produce it at 2 p.m. We'll accommodate you. But do it tomorrow.
Colleagues.
Item 19.
Yes.
It is not behind our from the last 40 days. His daughter name it is in the script. And you can pay 7 with the FIR. There's some. Look at the raise there. FIR. Arrangement. We give a strict, this is informative, also at about 11:15 p.m. When all of our family members, evaluator helper, so and so, were sleeping there at around 3 10 AM, some unknown culprit 6 to 7 entered in my house. The son of God, their received case amount of which 11 lakhs 45,000 along with good on. And what would be 6 lakhs? I'm not done it. I can have a good madam. Page 10, madam, this is the wording report, madam. Page 10, is the wording. 2 persons were arrested, madam. Or a paragraph 2, madam. Abdul Kabi and my lord Kasemal. These 2 persons were arrested, madam, and these two persons were implicated. And my lord, these 2 persons are already granted bail, madam. But some of them, one is in the record, madam. Record, madam. Abdul Kabi was released by the Samadhi, madam. And my lord Kasim Ali, madam, he was granted bail by the district supervisor.
Page number 10.
Is there body? Paragraph 2, madam. During investigation, 2 persons named Abdul Kadir, and Katim Ali, looking for help and assistance and being forwarded to the honorable court.
Who is the Miraj Ali?
Next word. During the time of interrogation, Abdul Kadir has revealed in his statement that he, along with 5 others, committed the offense. In who is it is came to know that one Miraj Ali.
That is the petitioner.
And remember Abdul Kadir, madam, well, already done it. That is another. This order is in the report. For 41 days.
Where is the order of the bail?
Abdul Kadir.
No, this
In
is
the report, madam.
Huh?
In the file, madam.
separate.
Last of the report.
Yes,
My lord, today only 40 days notice, and there are my lord intimating material that has been collected by the IO notice. And then my lord stolen property that those are yet to be recovered. So I have from this notice drafted releasing him on bail at least. Today is only 40 days.
what does your CD say?
The series is notice the accused person, my lord, the co-accused is implicated because one accused arrested notice. On the basis of this statement, my lord, the other accused person arrested, including it is Miraj Ali notice. And even in the Miraj Ali statement, also he himself also having to mother from the report of investigative officer. That how he has committed the property notice.
But both persons are Abdul Kadir and Miraj Ali, both were granted.
Abdul Kadir has been granted bail.
But even Miraj Ali has also been granted. No, this page 11.
No, Miraj Ali is the petitioner.
So Miraj no, madam, Abdul Kadir, madam.
Kasem Ali.
Kasem Ali.
Question is there after how
Both
many
were granted.
days?
40 days behind.
This person is on 40 days notice.
You see bail petition. No, it's not about days, it's about the investigation.
Yeah, the
How
investigation is pending because of the stolen property yet to be recovered. If they are released on bail, how the investigation would be able to recover those articles?
You've not paid for cancellation of bail for the other accused.
Other accused,
Is it available from the case diary that these accused who have been granted bail, against them there is no material? You have accepted this bail order,
it is there, against Abdul Kadir also wrote there are materials.
but then you have not paid for cancellation of the bail. Your CD must reveal that there is investigation carried on, proper investigation carried on. Really putting somebody under custody and saying that you get up-to-date instructions if you want. When is your CD? When is the CD? When is the last entry?
And last entry is going to up to 25.
It will be after 2 weeks, about 10 days time will be done.
No, not 10 days time. You find out what is the status of the investigation. Maybe putting somebody behind the bars and saying that recovery not made, investigation not carried, you have not prayed for cancellation of the bail.
Even Abdul Kadir was granted on 3 open.
But he was arrested earlier.
Yes, sir.
Then they were not arrested on the same day.
No. And the basis of his statement,
Whatever, he was arrested on 27/1. You have a look at this order also if you want. Go through, get your information. We can defer it by 1 week. Let him obtain the instruction. List on 20. 20.
my lord.
20 June.
Yes, my lord, this pattern we have to release after the more than 60 years.
It's not about more than 60 or 30 or 40. It's a question of why do you want him for custodial detention?
Because of this, what I found from the case, there is a comes to the property yet to be recovered.
So yet to be recovered. What is the IO doing with regard to that? There must be meaningful investigation.
And it is 20, when occurrence took place on 24/1.
This concept of 30 days, 40 days, you have to get over with it.
My lord. The occurrence was on 24/1, January.
Unless you have a reason for keeping a person under detention, that yes, we are getting information or making progress by keeping person under detention. This concept of 30 days, 40 days, this is given to you so that you can carry out the investigation.
Right.
And at the end of 60 days or 90 days, you don't file the charge sheet.
Let it up 20.
Let the learned APP procure the required instructions with regard to the progress of the investigation made insofar as the petition is concerned. In connection with the so-and-so case, place the matter again on 2006. Directly give to obtain required instructions and permission for the court. Mr. So-and-so appears for the petition.
I have to just handle the case. Otherwise, it will be difficult for them to give any detail.
Learned APP is permitted to send back the case ID, however. The same be produced again on 20, along with up-to-date progress regarding the investigation carried out. As well as the status of recovery of the items stated to have been stolen. You produce it positively on 20 with the instructions. Or we'll make it 22. Just 2 more days. 22.
Rating of 23. It is 60 days. Okay,
Either 20 or 22. 22. Let it be on 22.
Item 18.
Next figure. So if the petitioner is setting trial, the section 6 of the POCSO Act. And he is behind the bar. Is 2/7/2021, now nearing 2 years.
To take it up with the registry. Let it be listed before appropriate bench. On an early date.
Item 20. Already in the proceeding for 56.
Where is your FIR?
Case 12.
Where is the FIR?
Case 12.
Case 12.
Giving a pay function from Polygon. Physical this two groups of QTR.
Yes.
The accused person, main accused person has been arrested and 4-5 witnesses has been the statement of the 4-5 witnesses recorded in consequential statement. Everybody has stated that who has committed the offense. My name is nowhere mentioned.
What is the FIR at page 15?
Few FIRs been logged, others. Same or occurrence, same incident. Later on, section 307 has been added.
Yes, CD.
My case is difficult.
What is there?
Looks like kindly favors page 24 of the bail application.
24. Yes.
Ground of arrest notice. Number 4. The arrested accused person is Sriman Hazarika provoked to other arrested accused person to commit this as heinous crime. But here what I found from the case that is injury inflicted by one notice rupiah notice. He was along with this Sriman Hazarika, and they were fighting two group of young person in a few function. Then was the rupiah notice, he inflicted the injury. But this person, with whom we initially fight started.
What happened to Rubial?
4 or 5 witnesses have been.
What happened to Rubial? Is he in custody?
Yes, he is in custody.
I have standing there, you know, not fighting.
So
4 or 5 witnesses have been examining your project. Everybody, once your statement has been recorded, everybody stated that Rabiul Ali has committed the offense. My name is Rohan.
I started with Sriman Hazarika notice. Then
Only one of
two group of people they started sitting each other. And rupiah.
no, what as per your investigate? What is there in the CD in respect of the assault? Who caused the assault? Who caused the injuries? What are the injuries?
Injuries was it,
One person has died.
yes.
What does the postman?
What the report is saying?
What does it say?
I don't. There's an injury in the face notice and forehead notice, then in the abdomen, different part of the body.
You give us the CD. You mark the portions. Relevant
Relevant
portions. Yes. Give it.
Then the person who is in injured, you know, his one picture taken has also been recorded. He has been also been attacked by Rabiul Ali. My name is Noble.
Section 34 is there. It is also been like another section 302 and 34.
FSL report not received. FSL report not
The
received.
report is pending.
Who is Simran Nazarika?
I am Simon.
Petitioner.
Yes.
Where is the statement of the accused petitioner?
It is there. I find.
Like what? Okay. The flag marks it is not there. One counsel for the parties. Yes, they can fight by the. Taking bail and he was arrested on. When was he arrested?
74.
Arrested on 17/4/2023. And has been in custody since then. that a learned counsel for the petitioner submits that in a file dated 16/4/2023 was lodged by the informant one Raj Kishore Yadav, alleging that his son was assaulted and stabbed by some persons. So he was admitted to GMCH hospital, but was declared dead. Therefore, the FIR was filed requesting the police to investigate into the matter and arrest the culprits. Also, the said FIR was received and registered as Maligaon. What is the case number? Maligaon PS case number. Jalubari PS case number 229 of 2023 under section 302-34 IPC. Headed section 326-307 IPC. Learned counsel for the petitioner submits that the petitioner is not responsible for the offences alleged. The person who allegedly committed the offence was also arrested. Other person also arrested, has already been arrested and is in custody. Also, the learned counsel for the petitioner submits that there was a fight amongst two group of boys. However, the offence of stabbing and assaulting the deceased person was not done by the petitioner. Also, he therefore prays that the petitioner be released on bail. And at this court, by the order dated 22/5/23 called for the CD. So the CD is called for has been produced by the learned AKP. Also peruse the CD as produced by the learned AKP. Also, from the CD it is seen that investigations have progressed in the matter. The post-mortem report does not opine the cause of death, and the same is kept pending in receipt of report from FSL. FSL report is awaited. FSL report, however, is not part of the CD as called for. Also, from perusal of the CD, it is seen that the allegations made by the witnesses examined, from the statements of the witnesses examined, it is evident that the act of physical assault and which may have led to the death of the deceased was caused by some other person. Also, at this stage of the investigation, this court does not find sufficient incriminating material which suggests that further custodial detention of the petition is necessary for investigation of the case. Also, no materials are also found to suggest that the release of the petitioner at this stage of investigation will hamper the investigation that has been carried on. Also, consequently, this court is of the opinion that the prayer for bail can be allowed. Stop the petitioner is directed to be released on bail upon furnishing a bail bond rupees 30,000 with one local security of like the satisfaction of Indian Kamru Factor. Most of petitioner will continue to appear before the IO till completion of the investigation on every date as required. Also, petitioner will not move out the jurisdiction of Jalubari PS or change its residential address without written order of the competent board. Bail petition accordingly allowed in this course of CD return.
Time being item number 53.
Any instructions?
No, I have been informed that the concerned messenger is on his way to deliver the deportation. So can you be on date tomorrow or after tomorrow?
Day after? Day after tomorrow? Tomorrow?
And only is regarding apprehension, my lord, I can tell you of it. My lord, the certain things we cannot keep written. So what happened, my lord, when I went there on 18/5 to the police, so they did not write on the statement whatever I had stated. The other, my lord, I know possibly is a very nice person. He suggested me to file an application for NCC. And therefore I am before your lordship. Even, my lord, I got a call yesterday also. So that is my only apprehension. Otherwise, my lord, is a practicing lawyer of the court for last 20 years. And your lordship will find that the allegations set forth in the FIR. There is nothing against me. The
Why, if he is there, we'll take it up at 2. Why tomorrow?
Lordship, tomorrow, Lordship.
No, at 2. Second half.
if it is coming there.
No, if it is on his way, then
Lordship.
after, any time after.
Second half, Lordship.
Second half, yes, second half.
Madam.
Item 21.
Wait, this is lordship. Lordship, this is 439 bail application, lordship, 390 days in jail custody, lordship. Elsewhere, scan elsewhere was called for, probably.
Probably it is not available. There's an office note, as per office note. dated
Scan copy not received. List after a week.
Lordship, can it be on Monday, lordship, 390 days in jail custody, lordship, out of 15, lordship, forward has been 80.
All right, let it be on 19th. List on 19th.
Highly object,
Registry to issue reminder to fill for scan copy.
highly object.
23.
Yes.
Yes, very much for in this matter, your lordship. Your lordship, we'll find a FIR, or particular FIR on page 17, your lordship. Your lordship, only your lordship against the accused number 2. Your lordship, item number 51 is the connecting matter, your lordship. It pertains to the same case company, your lordship. Your lordship, only there is allegation against the petition number 2 of item number 23, that he used the south week. Against the petition number 1 of this case of this item, and against the petitioner of item number 51, there is no such allegation, your lordship, except that they use laughing. Only one line, your lordship. And my humble submission is that, your lordship, there was no sub-weapon that was used, your lordship. There was a scuffle, there was some land deals, your lordship. They had some pending money, your lordship. Because of that, some scuffle took place, your lordship. And this FIR was not, your lordship. Nowhere, your lordship, 326 IPC or 327 is affected, your lordship. Will be affected.
Yes, CD.
In respect to item number 23, of the way this is the case, that
Is it not arising out of the same FIR?
51 is also from the same.
Same FIR.
51 is from the.
This is item number 23. Vishwanath Charili PS case number 66.
Item number 23, the petitioners of item number 23 are accused number 1 and 2, and the petitioner of item number 51 is accused number 3.
23 is accused number
1 and 2,
1 and 2.
and 51 is accused number 3. Accused number 4 is in the engagement, your lordship. He is not yet arrested, your lordship. He has approached this court by way of an anticipated bail application, your lordship. He has been granted indictment. Nothing has been mentioned against him in the FIR.
Yes, FIR.
There are allegations against one of the Anwar, also the other accused party also together. The Anwar notice appears by the petitioner in item number 23. Petitioner number 2 in item number 23. The key secretary notice now closed. And the injury report is notice previous notice. This substance head injury.
Weapon is seized.
Weapon is minor. That investigation is pending for the.
Yes.
It's application is pending.
What about the person at item 51?
My lord, they were also, my lord, present, Lordship, they also accepted, Lordship. Anwar was Lordship, he dictated the Lordship, down floor, Lordship. And the other equal person, Amri, uploaded Apsa. They also, Lordship, my lord, used Lakshi, Lordship. And they started with the Lakshi.
Yes.
Lordship, my instruction is that your worship during the course of the scuffle, the complainant fell down, he sustained some head injury and it was not dangerous enough. For this injury to be previous, your worship, it has to satisfy section 320 of IPC, your worship. Whether it satisfies section 320 of IPC, your worship, there has to be looked into, your worship. And whether it was, is there any evidence of it in the medical report or in the injury report that he was still hit with a sound with the neuro? Or it was just an injury, you can, the injury may take place even by falling down.
So that is a matter of Lordship trial also. So at the time of it, there are mental against the person.
Lordship, that witness is also not this.
The investigation is going on.
Lordship, they are behind the bar for more than, for around 1 month. The condition number 1 and 2 of item number 20.
Yes.
Today is only 29 days, the investigation is still going on. Lordship. It is not that Lordship, there is no material at all. Lordship. There are material against the accused person. Lordship, in the, even as the minor 18 person here, indicated all the accused person.
If the Lordship goes through the FIR, your Lordship, it's a very simple FIR.
Let us see this CD.
Against the other two additional, there is only one. They also use that.
There are some land disputes, this is true. They, Malad, owner one Rodil of the land.
Is the, come to page number 11. Come to page number 11. In your FIR, all these translations you make, you don't care to check. Who is the informant?
So Lordship, impairment is Hussein Ahmed.
Huh?
Hussein Ahmed.
And who are the other persons? Who are the other persons? Page number 11.
Lordship,
Do you have a translated copy?
Lordship, these are the accused here.
So what have you written here? You have to be careful about your translations. The statement of Anwar. He is referring to some Anwar. Who is the other Anwar? There are only one Anwar. There is only one Anwar.
No, one is also maybe informal also.
No, informant is Hussein.
One Anwar went with Hussein.
Huh?
One Anwar went with Hussein here to collect the money. So Hussein is saying that I along with two BDP member and one Anwar who is my brother went to the house of
Okay.
Either Barnacular or to will find it.
So there are two Anwars.
Ratipa, Moyer,
One was
I
in
think
the side of the, I was one in the side of the informant, other is the accused number two.
So there are who suffered the injuries?
Just about the state after.
Your lordship, yeah, Hussein Ahmed says that Anwar went to hit him, then while his brother tried to save him, he hit him. It is- like,
So Anwar, who's the brother of the informant, was
also,
injured
he was injured by another.
by Anwar.
By. That's what, that is the case.
Today, how many days? How many days today?
Today 29 days process.
Further custody is necessary.
So the STS process for this Anwar Hussain, here the pictures are now uploaded. It is of 326. So there are vectors in the case study.
Learned counsel to the parties. This the petition is filed by the petitioners. 1 and 2. Seeking bail as they are arrested in connection with Vishwanath Charity PS case number 66 of 23 under sections 1 so. It's alleged that an FIR dated 14/5/2023 was lodged by the informant one Mohammed Hussein Ahmed, wherein it was alleged that on 5/2/2023, wherein it was alleged that there was a fight between the petitioners and the informant and his brother in respect to the sale of a land and the transaction of money between them in respect to the land so purchased. In the ensuing fight, the petitioner number, it is alleged that the petitioner number 2 assaulted the brother of the informant, who is also named as Anwar Hussain, and with a kukri, because of which he sustained previous injuries on his head. Also, pursuant to the investigation lodge, the petitioner has been arrested in connection with the aforesaid case on 15/5/2023, and since then they have been in custody. Also, this court ID order dated 31/5/2023 had called for the case that also CD called for has been produced for this court. CD produced has been carefully perused. From the CD, the injury report is seen where it is stated that the injury sustained by the brother of the informant is also named as Anwar Hussain, is stated to be serious. It's stated to be grievous in nature. Matter is under investigation. The statements of the petitioners along with other witnesses have been recorded. So at this stage, this court finds certain incriminating material so far as the petitioner number 1 is concerned. Petitioner number 2 is concerned. Considering the stage of the investigation carried out and the materials which are available, this court does not consider it appropriate to grant bail to the petitioner number 2 at this stage of the investigation. However, no such incriminating materials are found in respect to petitioner number 1. Also, no materials are also found in the CD to suggest the release of the petitioner number 1 at this stage of investigation because any impediment to the investigation carried on. Accordingly, the CD petition is partly allowed. Petitioner number 1 is directed to be enlarged on bail upon furnishing a bail bond of rupees 30,000 with 1 potentiality of like amount, subject to the satisfaction of the CJM Viswanath Charity. Also, petitioner will continue to appear before the IU in connection with so-and-so case as and when required till completion of the investigation. Petitioner will not leave the jurisdiction of Viswanath Charity Police Station without written permission of the court. So far as the petitioner number 2 is concerned, the prayer for bail at this stage is rejected as incriminating materials are found in the scene. Bail petition is accordingly partly allowed at this point of security. 1 is granted, 2 rejected.
And is the accused number 3?
51.
51.
51.
51. Okay. Is the accused number 3? So it is similar to accused number 2. You are accused of using laughing approach.
What do you say about accused number 3?
But it will be the same notice because the injury is only one. Litigation was against accused number.
What is the name of this petitioner?
He was also present notice. He also assaulted the other person.
Amir.
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 The accused number
There are no materials against him. Petitioner in this item 51 also released from bail in similar terms as the petitioner number 2, sorry, petitioner 1 in the early case. Same bail bond, same conditions. This was and see the return.
Item number 24.
Yes, yes.
My lord, case you must call from, what has happened, from last Friday, one item was moved, as item number 24, BN number 1883. Of 2023, wherein the city was available. And this is a matter, connected with that, same police station case. And my lord was also pleased to grant bail to those, arrested accused. The present petitioner is also similarly situated. Perhaps, it is not available with my learned friend. It is in the, perhaps in the office, so can it be taken up at 2 p.m.? At 2 p.m. My
What is the petitioner here?
lord.
What does he do?
Lord, he is the accountant in the concerned Gaon Panchayat, Lord.
He is the main person.
My lord.
He is the main accused.
No, my lord, before I joined in the, before I joined in the office, all these documentation and the particulars were prepared. And I as an accountant, only the person deal with, the financial transaction,
That's the primary allegation.
My lord.
That money was released in name of certain other person by
Exactly,
forging documents.
Exactly.
So you as the accountant, how will you not know?
No, my lord, I cannot prepare the list of the beneficiary, my lord. If there is an online system, is there, my lord.
But you are the person who has released the money.
No, my lord,
You have to make all, you have to take all steps to ensure that it doesn't go to
Lord, I
person not required, not mentioned.
My lord, I am not the responsible for releasing the issuance. It is the Gaon Panchayat president, and I am only the person dealing with the accounts department.
So what do you do with the accounts?
Not just maintaining the fund, what is the inflow and outflow.
Who signs on the checks? Who releases the
I am
money?
not signing the check. My
Who
lord,
really-
very well.
who
The
signs
Gaon Panchayat president and the other members are there. Accountant is not.
You are the accountant, you are the
Secretary
accountant,
is also there, my lord.
you are the accountant of,
The concerned Gaon Panchayat, my lord, that is the Velopuri,
Tulsibari.
my lord.
Yes, get the CD if it is available.
My lord, 2 papers. Well, Tulsibari Gaon Panchayat. Well.
Item number 56.
The lordship. My lord, in this item number, my lord, 56, my lord, this is regarding Sunbury PS case number, my lord, and the period of detention, my lord, 58 days. My lord. And item number 57, my lord, that is my lord, Hordomu PS case number, my lord, that was shown in from my lord. Shown in from my lord, 9/5/2023, my lord. The period of detention 35 days. And considering the period of detention.
Considering period, what is the statutory period?
60 days.
60. 60.
Yes,
Today is
58.
defer it by 2 days. That will be on Wednesday. Mr. Burwa, unless you want to submit that charge sheet has been filed. What is the stage of investigation?
Investigation is pending, but also the case to recover. The other accused person is recover, and these persons are they are better and good. Because the other case, the Hordomu case,
But you are aware of the position in law, statutory period.
regarding also item number 56, today is 58 days. So I leave it to your lordship.
Let it be day after, today is 58. On on Wednesday, day after tomorrow. You maintain, you keep the CD, retain the CD. List on 14th June. CD receipt be retained.
Item 57.
57 statement. By board of PS cases.
In this case also, it has been identified through the CCTV footage also. The same case also. His next one,
Same.
same of a open.
He's connected with the Chanmari case also.
Okay, sir, somebody case he has been arrested also. He was arrested by public also. Was missing the gold state also. In other case also, while he was in custody in Thalmari PS case, he has been thrown arrest in this case also. Because he has been identified through CCTV footage.
Yes. When was he arrested?
When its own arrestment of 9/5/2023, the 35 days like. In this.
You have the CD.
Yes, yes, sir.
Old move.
Old book.
Where is the FIR?
The current ballot is page 8. Page 10 ballot type.
Where is the report of the CCTV?
That is the note of the investigative. That the CCTV footage has been changed also. And purpose has been identified.
They are a positive finding. You are identified. Third learned counsel for the petitioners, for the parties. This clear petition is filed by the finance minister who was arrested in connection with Order book PS case number 122 of 2023 under section 392 IPC. Postal Government Council Communication submits that by FIR dated 13/4/2023, the informant had lodged the FIR alleging that two persons had snatched away her gold chain on 13/4/2023 at 12 p.m. near the place of occurrence mentioned in the FIR. The case was registered as PS case number so and so, and pursuant to the investigations carried out, the petitioner was taken into custody. Also, petitioner was arrested on he was shown arrested on 9/5/2023. Why was he shown arrest?
My lord,
Why was he shown arrest?
my lord, because you have already been arrested in connection with unmarried case.
The other matter.
In other matter.
He is also arrested.
Yes, this is the same person. He was arrested in connection with unmarried case here. So independently, because this occurrence took place on 13 the boardroom case.
What is the name? Oh, the same person.
Same person.
Oh, same person.
Boardroom case also, the occurrence took place on 13. And unmarried case occurrence took place on 14.
Okay.
That is why he has been identified.
This we are keeping it on.
On Wednesday.
Earlier matter, Wednesday.
Day after tomorrow.
All right, then both matters on Wednesday. Both matters on Wednesday. Yes.
Item 58. 80. So in this case, I think custody was 75 days. Short is my currently page 20 years for a moment. Do coming to the FIR. Page 29. This is the birth certificate mirror of my child. I was born on 10/6/2022 mirror. Just completed 1 year mirror 2 days ago. And page
So this is the second bail, third
that's it.
This is the- third bail petition.
And page 31 mirror plastic pregnancy. And this medical certificate of my wife mirror. She is suffering from viral hepatitis mirror. Advice complete paper.
Yes,
FIR page 13 mirror. 75 days I have complete.
yes, Mr. Counsel, AVP.
My lord, 395 notice, that is my lord. The lord, this is the FIR mirror. To the actual, the case is concerned, mirror, at least exaggerated mirror, from the FIR page 13 mirror. In this, we are not just 50 meters, but the case is exaggerated. From time of it is took back from the FIR. Page 31 thing. The FIR injury report was the injury is minor injury, and minor regarding the property also. That is minor, I think where some money and goes and etc.
Third, another counsels for the parties. This bail petition is filed by the petitioner. Praying for bail as he was arrested, collection in Lambari. PS case number 71 of 2023. Registered under section 395. And so and so and so. And FIR dated. Where is the FIR?
Page 13, one thing.
FIR dated 28/3/2023 was lodged before the Matahi Lambari police station. Alleging that on 27/3/2023, at about 11 p.m., group of 10-15 youths attacked the informant and 3 others. Three others, along with the informant, in front of a shop near the battalion gate. Post of it is alleged that the group of miscreants specifically attacked the informant and took away the mobile phone from a money bag and cash amount of 2 lakhs, as well as the gold chain of his colleague. Post of it is alleged that they would be miscreants attacked with rod, bricks, belts, iron, and knives. And it is further alleged that the owner of the said store is suspected to be involved in the same incident. Also, in the same incident, the windows and doors of the vehicle which the petitioner, in which the informant and his associates were traveling was also broken. Also, the said FIR was registered as the aforesaid case. Pursuant to the investigation, the petitioner was arrested. Where is the first order?
First order is page number.
On 25/4/2023, in this court rejected the bail application number 1273 of 2023 filed with the petitioner. Subsequently, the second bail application was filed, which was also rejected on 22/5/2023. In bail application 1585 of 2023 on the ground that no new grounds have been urged in the second bail application. Also, learned counsel for the petitioner submits that the petitioner has been in custody for 75 days. Also, it is further submitted that he has a child was born to him on 10/6/2022. And the council has referred to the birth certificate issued by the competent authority dated 3/8/2022. Also, the council for the petitioner submits that his wife is undergoing various health issues and there is none to look after his wife as well as the minor child. Also, the council has referred to the medical certificate issued by the medical officer of Hiranpara FRU, NXC, DMC, Hiranpara, ID certificate dated 2/6/2023. Also, as per the state certificate, it was stated that the wife of petitioner was suffering from viral hepatitis with fever and headache for the last few days. And she's been hospitalized and under care since 26/5/2023. Also, she is advised complete bed rest. So, under such circumstances, it is submitted that since the investigation has progressed sufficiently in the matter, and further custodial detention of the petitioner is not required. Petitioner be enlarged on bail as prayed for. Mr. Arborwan and counsel to the petitioner submits that. What do we submit? Further custodial not required.
One of the
Investigation is progressing.
they are regarding nothing with some money and book and. Somebody on the mother, injury report is that is minor.
It is submitted that the injury sustained by the informant was shown to be minor. Although the items stated to have been snatched away by the snatched away from the informant has not yet been recovered. Also, upon hearing the learned counsels for the parties and complete perusal of the CD, this court is of the view that since the investigation has progressed sufficiently and the police has not yet filed the charge sheet from the perusal of the CD along with the perusal of the CD, it is seen that the statements of the petitioner as well as other witnesses have been recorded. Investigation has progressed. Also, some of the CD has not been filed. There is no material to suggest that further custodial detention of the petitioner is necessary. Post office is also submitted that it is also seen that no materials are available to suggest that release of the petitioner from custody in view of the ground search by the counsel for the petitioner will hamper the investigation which is being carried on at this stage. Also, under such circumstances, this court is of the view that considering the period of detention undergone as well as the extent of investigation carried on, further custodial detention is not required for the purposes of investigation of this case. Petitioner is accordingly the petitioner is accordingly directed to be released on bail upon furnishing bail bond of rupees 30,000 with one local security of like amount to the satisfaction of the arresting authority and subject to the following conditions. Sorry, satisfaction CJM come at Metro. Petitioner will continue to appear with the IU as and when required till completion of the investigation. Petitioner will not leave the jurisdiction of Fatahilambari police station without written permission from the court competent. Bail petition is accordingly allowed and single return.
Item 29.
Yes,
Then he was called for it in a very version. I'm on the interview.
CD
It's very not present.
is submitted by the learned executive as CD call for has not been received. Accordingly, let the matter be listed on 21st of August, enabling the learned executive to call for the CD. Interim bail granted will continue based on 21st August. 21st August.
I think that can it be of 23rd or 19th? Near the date.
23rd August.
Items 31 and 32.
CD,
Here also, cities are not available.
same order.
It is there.
Huh?
It is there.
Yes.
On
21st. 21st
20.
of the matter.
33.
33 also same period.
You're not interim. You're not on interim. You're not on interim.
No interim.
Then where is it coming from?
It's from Borpeta PS.
Then why are you taking so much of time? What is the FIR? Where is the FIR?
State number 10.
When will you get it, madam?
Lordship, on 20, Lordship.
20.
Lordship.
Interim will be
On 20. We have already passed an order that interim to be considered upon perusal of the CD. That order is already there. So let it be on.
In the FIR itself, my lord, see that my lord, by the committee inspection, so that therefore, and if the case is already registered. by the police. Thereafter, subsequently filed this area.
A little beyond 20,
No, sure. Along with the postmortem report.
let the CD along with PM report be produced on the next date fixed by the learned APP. Mr. So-and-so, the counsel is for the petitioner. List on 20.
20 of lives.
34. These are what should come. Successive bail application by doctor. Again, it was rejected. I had filed in my lord, actual affidavit. Reading over the new grounds, my lord, as well as the law, my lord, on which this certain affidavit finding the petition has been referred to. Well, basically, if the lordship kindly done to the annexure which I had given my lord, which was not there, my lord, in the earlier round of the petition which was placed with the lordship.
Where is the FIR?
FIR is a kind of page. Page 21, madam.
Vigilance case. Yes, then
Then we were pursuant to the earlier application, which has been filed matter. I was granted the liberty to appear before the IO. And I appeared before the IO on three occasions. And whatever was required of me, matter, all manner of statements were given by me, matter. Thereafter, matter, the petition was accepted. The revision of the case. No matter I say, while matter, using the petition, matter, by the final order matter. It was stated that, my lord, there was a transcription, my lord, which was there, which showed that I had talked with this complainant, my lord. I don't deny that I had not talked, but my conversation with the, my lord, this complainant was as regard to the deficient number of beneficiaries which she had not given before me, my lord. I was in, my lord, pretty much like inspector, my lord. And, my lord, by my duty, I am required, my lord, to collect the data of all the beneficiaries so that whatever benefit we give, my lord, that is recorded, my lord. So my conversation was limited only to that, my lord. Thereafter, my lord, these were done, and if the lordship now comes to the actual affidavit, my lord, which I have filed. And if the lordship finally comes to page 43, my lord, of that actual affidavit, there is a document which I had effected given back. Turning page 43, my lord.
additional affidavit.
Yes, madam.
Not available here. I think. Additional affidavit is not available. When did you file it?
I filed it, my lord,
Not here.
on 30th of May, my lord.
Not here. Not here. We can directly raise the court directly. That's what we can do. Now, the counsel for the petitioner, Mr. Chaudhary, submits that an additional affidavit has been filed on 3005
304.
on 2023. Also, however, the same is not available in the case reports. Most of the registry is directed to verify and trace out the state affidavit stated to have been filed and connect it to the case report. Mr. P. Barua appears for the respondent state.
My lord, that document which I have brought by way of the section affidavit. I will look for the, I have also provided it to you, perhaps that is there on the record.
If you have filed an additional affidavit, it should be available. If you have not filed it, then
I'm-
we can have a look, that's a different issue. You have filed it, at least after a week,
It will be, my lord, little earlier than that,
16 or 15,
115 time,
huh?
15, 1 time.
15.
Yeah.
15. CD receipt be retained.
35.
Wait, this your lordship question. Very possible amendment for timing.
We take it on some other day, CD receipt.
That's
So let us have it on Friday.
right.
CD receipt be retained. Friday. You are on interim.
Like,
36.
Yes. CD.
The section submitted.
Charge sheet submitted, madam. It is submitted by the learned APP that charge sheet, ID charge sheet number
82/23.
82,
82.
52 of 2023 dated
Dated 17/5.
17/5/2023 has been submitted by the IO. Accordingly, this bail petition stands closed. Petitioner is at liberty to appear before the competent court, for which the charge sheet has been submitted and wait for filing appropriate applications for bail. MS so and so, learned counsel appears for the petition. The petition stands closed.
37.
Bail petition closed, you appear before the court. All right, CD,
CD receipt.
yes,
We come to the any interim date. Other requisition must be. It is listed my lord injury report shows my lord it's a temporary injury report.
where is the FIR? FIR
That are 15, my lord.
50,
File number is 19. Date of occurrence was 1/7/2021. Then after 2 years, 15 to 2023.
Yes,
Here, immediate report shows that my lord is non-trivial.
anything else?
It says that it is a fight between two and this.
Same family.
Accused person, father same family of the informant. Accused number 3 is the nephew of the informant, and accused number 1 and 2 are the brothers of the informant. Okay. Accused number 4 is the sister informant. That is why got the accused number 3.
No, accused number 1 and 2 are brothers. You're saying they're brothers,
Brothers.
but the father's names are different.
No, my lord, same brother.
Huh? Not same brothers, not same blood brothers.
One Saikya, other Saikya, both are son of Vidam.
Yes, let us see the CD. CD.
Yes, sir.
Learned counsels for the parties. This heavy petition filed by the petitioner 1, 2, 3, 4. Apprehending arrest in connection with Common Court TS case number 39 of 23 under section 20. Learned counsel for the petitioner submits that an FIR dated 15/2/2023 was lodged by the informant, alleging that the petitioners as accused persons had assaulted the informant, as a result of which he was severely injured. And thereafter an attempt was made to kill him. However, when there was a hue and cry, the petitioners fled away from the place of occurrence. Most of the informant was thereafter taken to hospital for medical treatment. Also, pursuant to the FIR being lodged, the investigation will carry and apprehending arrest, the present petition has been filed. This court, this court, by an order dated 26/5/2023, granted interim protection to petitioner number 4. Also, CD was called for, whereas CD called for has been presented before this court. The CD has been carefully perused. And from the injury report, it seems that the injuries sustained, alleged to have been sustained by the informant, are stated to be non-grievous in nature. Also, the matter has been investigated upon by the IU. Statements of the witnesses have been recorded. Full stop. Perusal of the CD does not reveal any material to suggest that grant of interim bail to the petitioners would cause impediment to the investigations carried on. Full stop. It is also not seen from the CD. It is also seen from the CD that the petition number 4 appeared before the IU upon grant of interim bail, and statements have also been recorded. So, considering all of the above, this court is of the view that the interim bail granted to petitioner number 4 can be made absolute, and the same is hereby made absolute on the same terms and conditions given in the order dated 8/5/2023. Also, having perused the CD and having found no materials incriminating to suggest that similar benefit of anticipatory bail would not to be granted to the petitioner's command. This court is of the view prayer for anticipatory bail can also be granted to the petitioners 1, 2, and 3. So accordingly, if the petitioners are arrested in connection with so and so case, they shall also be released upon furnishing bail bond of rupees 25,000 with one local security of the like amount to the satisfaction of the arresting authority. Post of bail, petitioners will appear before the IU within 7 days from the bail. They should not take the jurisdiction, they should not hamper or temper, they shall directly or indirectly influence any person. Post of bail. CD bail petition is accordingly allowed as in terms of the allowed order. CD return. You appear within 7 days.
Okay. I'm explaining this for the item because you're.
Friday. You're on interim.
Friday, I will not be there, maybe on Monday, 19th.
19, all right, let it be on 19. You're on interim.
Yes, I'm on it,
We have directed the CD to be retrieved.
on 19th.
The key item. Huh? This was 19.
Item 38.
Somebody mentioned this matter? Yes, 38.
Here we have received the CD, but that is not up to date, madam.
You're on interim. Not on interim. What is the FIR? Where is the FIR?
Transcript copy is on page number 8.
Where can you get your updated CD?
Actually, here otherwise the postmortem report and all are here, but police has seen some CDR on the note. I have seen that they have seen the CDR record, my lord, because there is a note regarding the threatening of this by this accused person to the victim who committed suicide. So police were trying to verify the CDR report. The
You
last,
get it next week, 19th.
this is from Bongaigaon. We have to send it there.
Send it back and get it. How much time do you require?
19 will try. 19 we will try.
Let it be on 21st. Let it APP submits that some further time is required to complete his instructions in respect to the investigations carried out. He craves leave to call for updated CD. MS so learned counsel appears for the petitioner. And submits to the petitioner is not on interim being therefore. Matter be taken up on an early date. Accordingly, let the matter be listed again on 21st of June. And from which date we learn that we will produce the updated CD. This accordingly.
Item number 40. Is reading of discipline.
My lord, in this case, my lord, this is a tax effect case.
It can copy of
Tomorrow is the date fixed in the law.
What?
My lord, allegation, so far the allegation is concerned, but nothing, my lord, no case for against the present petition. Only against the one, my lord, he is not the petitioner in this case.
Where is your FIR? Where is the
I will
FIR?
come to FIR, my lord, till 30,
1-3.
1-3.
Yes. Who are the petitioners?
My lord, petitioner are my lord, their name is in the start sheet, my lord, kindly come to start sheet, my lord. In the start sheet, even in start sheet, my lord, nothing is there, my. Yes, that, yes, 17, my. They are the villagers, my. Yes, 17, my lord,
You never appeared before the police. You were never called.
my lord, the, then, my lord, as of date, my lord.
FIR is of
Always
20.
available in the house, my lord.
FIR is available on filed on 21,
Yes, ma'am.
2021. So you were never called by the.
No, my lord, no. They are always available in their house.
So therefore you make
Never,
that,
my lord, police are.
make that statement before the competent court and pray for me
Not tomorrow is the date fixed, my lord. And then.
tomorrow. When is the date?
Tomorrow,
Tomorrow.
yes. They will allow to, my lord, appear before support.
You appear
And
and
they will face the trial, my lord.
you appear and file applications before the court. Huh?
Otherwise, they may make a good penalty. One is a school teacher.
You have to hear it. from them.
Some
Yes, have you gone through the-
protection, I have done that.
Go through it. Go through it.
Protection will be given. Okay. On the movement, my lord, kindly come to case 28, my lord. This is the start sheet, my lord. Start sheet, my lord. Zohar Ali, page 29, my lord. He is one of the petitioner, my lord. No, my lord, Zohar Ali is the main, my lord. He initiated the, my lord. And my lord, my name, my lord, our name, my lord, Madhurani, page 30. Only, my lord, mention here his name, address, and my lord, brief of the investigation, my lord. That page, my lord. 36, my lord. This is the brief of the investigation. Nothing, no whisper against the presentation. So, my lord, they may allow to appear before this court, my lord. With some protection.
What is the stage of
Trial is, my lord, appearance.
appearance?
The accused, main accused was.
Yes, Mr.
There
Kaushik,
are other sections where also agree with them. 306 is also there.
you go through this and tell us in the second half.
Yeah.
Second half, we can go through. Like, that will be taken up again. We'll take it up in the second half.
My lord.
41.
CD along with.
Smile, basic mind. Both perfect, my lord. The fire is the state can.
Yes,
Madam, because this is the case, madam, along with medical report, madam. Yes, as part of medical report, the injury is serious manner. Injury is serious manner. Here, site of its injury, madam, left foot heel. As per madam, although it is not mentioned, madam, what kind of weapon inflicted, madam, but on the statement of the victim, madam, it is lathi, madam. Lathi, madam.
what is the stage of investigation?
Madam, investigation is going on, madam, then. Several witnesses examined, madam, one of the important witnesses are also there, madam. And in whose presence, madam, that incident took place, madam. Document statement of the madam. In his part in our house, madam. The incident took place. Your statement are also there, madam, accused person, they initially given the interim, madam, by the court below, madam. Thereafter, after going to the treasury, it was rejected, madam. Here on the statement of the accused person, they also admitted that they have assaulted. Victim statement are there.
The charge sheet is filed, so
That's not fine, madam.
not filed.
No.
But already petition statement was recorded.
But it was earlier, after going to the madam, it was rejected by the court below.
Where is that order? Where is that order? Rejection order?
Rejection order was it, I have not annexed. Also.
Oh. You have a copy with you?
I have a copy.
So we'll take it up at 2. I give us a copy. All right. You retain the CD.
Madam.
Who is appearing for the petition? NH Borvia. Just pass it over to the time. Yes.
Please come to item 53.
Yes.
That we have received.
Oh, what does it say? Case registered? No. Is the case registered against the petitioner?
Yes, option. It's between option. And the relevant portion I have flagged for approach, column C.
It is not a lawyer's job to go and verify the property. Nor is it his job to prepare a trace map.
No.
Why are they clubbing the valuer and the advocate?
It's a panel advocate.
Maybe his job is to see whether the document is in order or not.
No.
And he has relied on, I believe, some certificate.
Yes.
Non-encumbrance certificate.
No.
That is found in the okay.
Then if this is the case, then civil practitioners will be in difficulty.
Yes,
No.
nobody will like to give any opinion for the time.
Only indications that you also without verifying the required documents.
Where will he verify? From the registry?
Lordship, that they have not done.
But that is
No,
so
but-
much to say. If I take your lordship to the opinion given, I have enclosed it. The lordship will find, the lordship can be see at page 21 onwards. All the records have been verified from the sub-register office, it is found, these documents are all okay.
What more can he do?
And there is a NOC, my lord, in the NOC also, it has been given that it is free from all encumbrances. And three of the courts, my lord, district judges and the civil judge one, civil judge two, they have also given a certificate that there is no litigation pending.
Third, Mr. S. Dr. Leonard, senior counsel, assisted by Mr. S. Dr. His AV petition is filed by the petitioner, praying for anticipatory bail. As is apprehensive of arrest in connection with BIEO police station case number 5 of 2022 under section so and so and so. Learned counsel for the petitioner submits that an FIR dated there is no date in the FIR. An FIR was lodged by the Punjab National Bank,
Sick manager.
Chief Manager, Punjab National Bank, which was received and registered as BIU case number so and so. By the state FIR, by the state FIR, it was alleged that certain fraudulent transactions were carried out, creating void mortgages, irregularities in documentation, misappropriation of funds from loan account in order to defraud the bank. By the proprietor of one NAFNE Industries. Various other allegations were made in the FIR. During the course of the investigation, the investigating officer summoned the petitioner to appear before the authority concerned, before the IU. You appeared before the IU.
Right.
The petitioner is a practicing advocate within the jurisdiction of this High Court. He had given an opinion in respect of the documents which are presented before the bank for creating a mortgage. Full stop. Learned counsel for the petitioner submits that the opinion given by the petitioner in his capacity as a lawyer is based on the information made available from the sub-registrar's office and supported by such certificates of non-encumbrances as issued by the said office. So on such basis, he had verified the original papers and given an opinion that there is a clear, marketable and valid title over the plot of land and is competent and is available to create equitable mortgage over the said plot of land by the bank. Post of Learned Senior Counsel for the petitioner submits that the petitioner appeared before the IO and recorded his statements and made these statements, which however were not recorded. They were not recorded. They were not recorded. Subsequently, he's been receiving verbal calls, telephone calls from the concerned IO, requiring him to appear again before the IO in connection with the investigation of this case. Also, the petitioner is apprehensive that he may be arrested in connection with this case. Therefore, is straightforward. The grant of anticipatory bail. There are MS.SH Boran under APB was directed to produce the status report in connection with the so-and-so case by the last order dated 7/6/2023. Also, the learned APB has produced a copy of the instructions received, and on the basis of the same information received, he submits that that the case has been registered against the petitioner also, amongst others. Also, having heard the learned counsels for the parties and upon the perusal of the pleadings on record, this court is of the view that let further instructions be procured by the learned AVP in respect of the investigations of the case, and apprise the court on the next date fixed. In the meantime, the petitioner is arrested. He shall be released on furnishing a bail bond of rupees 10,000 with one local security of like amount to the satisfaction of the arresting authority. Petitioner will appear before the IO within 7 days from today, and he shall not move out of the jurisdiction of the PIO police station without written permission of the IO. He shall not hamper or tamper with any evidence, or he shall not intimidate or attempt to influence any person connected with the case. Place the matter again on 21st of August, enabling the learned APP to complete the instructions in respect of the investigation of the case. You may take the instructions.
No.
Item 41.
Yes.
This is the order of the learned court.
What was directed?
Madam, only saying that sufficient incriminating materials found. That's the bill was rejected and interim order was taken. But there are no whisper that whether I am unlawful. I was with any condition violated law.
Yes, Mr.
My lord. On the statement of the witness matter, it reflects that they have committed the offense matter. And also, my lord, after going to the case, their matter, the court has rejected their prior matter. Initially, interim matter was passed matter. And on the statement of the victim, it reflects that my lord, injury was caused by the person matter, and medical report supported this.
No, but for what purpose do we now want these their statements are recorded?
My lord, initially, my lord,
Then,
put below my lord.
then
But they after rejected after going for the record.
what purpose will it serve to detain them now? There is no indication here. That their custody is again required because of. Third councils, both parties. This AV petition has been filed by the petitioner. Nothing to. Praying for anticipatory bail. Apprehending arrest in connection with. Sonai TS case number 43. Of 2023 under section 22. It is submitted by the Learned Counsel for the petition that an FIR dated 22/3/2023 was lodged by the informant alleging that on 20/03/2023 at night about 10:30. The brother of the informant, while going to the house of another relative, was illegally obstructed and forcibly taken to the house of the accused persons named in the FIR and with the intent to kill him, hide him inside the house and severely assaulted the brother with sharp weapons. Full stop. After hearing the human cry of the brother, neighboring people informed the petitioner, the informant. And upon reaching the house of the accused persons, the brother was seen in an unconscious state. He was immediately taken to the hospital for treatment. Also, on the way to the hospital, we were again followed by the 8 accused persons. And were sought to be assaulted again. However, upon the police reaching the place of occurrence, the accused persons fled away. The injured was the brother of the informant was severely injured and was undergoing treatment at SMCH Silchar. This court by earlier order directed the CD along with the injury report to be placed before the court. The CD and along with the injury report has been placed before the court. Upon perusal of the CD along with the injury report, it is seen that initially the petitioners were granted interim by the Court of Additional Session Judge FTC Kashar. And the statements of the petitioners have been recorded by the IU. Subsequently, by the order dated 25/04/2023, upon perusal of the CD, the interim bail granted was cancelled. The bail petition was dismissed. Upon perusal of the CD, it is revealed that the investigation has progressed in the matter. The statements of the accused person, the petitioners have also been recorded. The injury sustained by the injured person is stated to be grievous in the injury report. Also, no materials are seen in the CD to the effect that further custody and detention of the petitioners are necessary for investigation in the matter. Their statements are already on record. No material to suggest that any of the conditions granted by the court during the currency of the interim bail earlier granted and been violated by the commission. Considering all of the above, and also considering the progress of the investigations carried out, as well as the statements having already been recorded by the IU, this court does not consider it necessary. This court does not find any condition, any reasons for further for custodial detention of the petitioner in the absence of any such materials to their effect. In view of the observations made about this AB petition is alone. Petitioners, if arrested in connection with so and so case, shall be released upon payment of bail bond of rupees 30,000 each with one total security like amount. The petitioners will appear before the IU within 7 days from today, and on such other dates as required. The petitioner will not influence any person or witness. Petitioner will not tamper with any evidence or any documents, and shall not leave the jurisdiction of so and so police station without written permission of the case. The AB accordingly stands allowed and disposed of. See the return. You can take like a copy. Order of meters.
Things up to item number 54.
We'll take up this matter at the end of the list.
Takes up to item number 24.
Mother, here as per information from our office mother, CD is available in a court matter. It was fixed on matter 9623 matter, lordship matter, and item number 34 matter. And similar matter is fixed on tomorrow also.
Let it be listed tomorrow.
Matter. No, as the CD is available, can it be available
Tomorrow,
tomorrow?
there is some other matter available and tomorrow.
Matter.
Is this matter again tomorrow? Along with
Matter. Along with there morning and
no, you said the matter is fixed tomorrow, some other matter.
Matter is inform my one of my colleague.
No, don't make mention like that. Then let it be day after. Day after tomorrow.
Finally, tomorrow, all other persons are released.
Is there any matter fixed tomorrow? That is what we want to know.
I'm not sure because I have the only this matter.
what is the other connection?
My contention, my lord, is that I am the accountant of Tulsi Pari Gaon Panchayat, my lord, joined in the year September 2021. Now, my lord, the allegation is in the FIR is there, my lord, let me take to tell you the FIR. Is that, my lord, page 17. That, my lord, some dead person's name had been included in the beneficiary list. In connivance mainly with the block development officer and who is an employee, my lord, of the concerned Gaon Panchayat had been arraigned as a, my lord, accused. Now, my lord, there is a detailed procedure is there, my lord, that how the beneficiary list is going to be incorporated.
What is the procedure?
Lord, the procedure is that the Lord application forms are come and online Lord I have stated in my petition also Lord. At paragraph 9 Lord in page 8. Paragraph 9 my Lord may kindly peruse.
Yes.
Page 8 my Lord.
We'll just check. If it is there, we'll take it up. Yes.
So, my lord, the present petitioner, my lord, who had also been arrested on the same day, my lord, on 13/5/2023. And my lord, we have already cooperated with the investigating officer, whatever material available or what is with my knowledge, my lord, I have given and cooperated with the investigation also, my lord. And thereafter, my lord, there is no investigation or no query has been put forward by the IO. My lord, the purpose for my custody, perhaps, my lord, third, my lord. It's nearly about.
What is your job? What is your job? What is your job profile?
My job profile is I am the accountant of the concerned government is required to keep hold of the account like the charter accountant who always keep the account of the concerned government that what is the.
So in the account, are you not required to find out who has received the money, who has not received the money?
I do not have any role regarding the preparation of the beneficiary. It is the concerned president as well as the secretary and other members who forwarded sponsored the list. Now, I as an employee, I have to abide by the authorities, the block development officer's instruction, and these facts are also being signed by the BDO as well as by the secretary jointly. As an accountant, I do not have any role regarding the release of the amount also.
No, but their submission, you have to show us from some document that you are not connected
No, the
in the
document.
process. You have no role in the process.
My lordship is, I fully agree with my lordship, but my lord, those documents, at this moment is very difficult to, exhibit before my lordship, as I am not in the custody, and the documents which have already been seized by the officer,
At least your appointment order or something. you
No,
put-
my lord, it is not dispute, my lord, may kindly see from the, from the FIR, it is, my name is there in, say, and the forwarding report also reveals, that page 24, my lord, 24, forwarding report, my lord.
No, we are not questioning your statement whether you are employed or not employed.
My
We are trying to understand what is your role.
role. That is correct, my lord, that is correct. But that document, my lord, I do not have at this moment with me, my lord, admittedly. Because, my lord, the role for that, my lord.
What is your name?
Parthopradin Soikia, my lord. But in the FIR, it has been written as a Bora.
If PD is available, we'll pass out. What can be done?
My lord has considered the other arrested accused, my lord. Similar benefit now also.
Subject to CD being available. Otherwise, it will be listed tomorrow. We'll pass orders. Pass orders.
Apply.
What is the item number?
24. Is that to item 40?
It will be connected, but it will go by. Yes.
I forgot a scan copy. Next, take it tomorrow for appeal.
Yes.
Next date is fixed tomorrow for appeal. For the incident is concerned, my lord, the victim committed suicide. That is because my lord, he saw that my lord, his wife was in a compromising position with another person, my lord, the main accused in the crime. Subsequently, my lord, desire was held as a down. And then, my lord, these three persons, they, my lord, said something to the my lord, husband of the dead lady, and he committed suicide.
Oh,
So this is the allegation.
I only submission is one for in the death. The petitioner may allow to adjust the. My lord, and some protection maybe. And they will pay.
why are you apprehending arrest?
My lord, in the FIR, their name is not there, but
Yes,
in their start sheet, my lord, and they come to page 36,
36.
36. It is in 32, my lord.
Yes.
Point number 40.
Hmm.
Their name, only their name has been detailed. No allegation, my lord, taken. Delayed meeting or death, my lord, my lord, settle the matter. In that time, my lord, the husband of the victim, my lord, he committed suicide. And main accused, my lord, he was arrested. And I am not for him. I am the villager. We are, my lord.
You are related to the main accused. You are relatives of the main accused.
No, my.
I am the husband of the lady who is a victim of rape. And then, my lord, one meeting was held in the village, and this petitioner, from whom my mother, they insulted the husband of the rape victim.
He committed
And
suicide.
he committed suicide because of that. So, against them, my lord, there is no allegation of 376. Against them, my lord, it was it.
But learned counsels for the parties, yes. We petition is filed with the commissioner. 1, 2, 3, 4. Petitioners apprehend that is connection with February case number 251 of 2021. Also, learned counsels for the petitioner subjects that charge sheet in the matter has already been filed by the charge sheet dated so and so, charge sheet number so and so dated so and so. The learned counsel for the petitioner submits that in terms of the FIR lodged by the informant, allegation is against the FIR named accused. So allegation is with regard to commission of rape. So far as the petitioners are concerned, they are not defined and accused. It is submitted that the FIR was lodged on 2021 and thereafter charge sheet has been filed. Now, the petitioner is apprehensive that upon appearance before the court, having competent jurisdiction, they shall be arrested. Also, this court had called for the scan copies of the case diary, the scan copies of the LCR from the competent court, which is JMFC Corbetta, in connection to DRC case number, DRC number 17 of 2022. For the perusal of the scan copies, it is found that the case diary is no specific material against the petitioners in respect of the alleged offences. However, their apprehension at this moment is that upon appearing before the court, competent court, they shall be taken into custody. We will direct the court to take into account the judgment of the Supreme Court and pass appropriate orders. Were you on bail ever? Were you on bail earlier?
No, man.
Were you called to the? Were you sought for? Were you detained before? No, you are not arrested. You are not on bail. So the judgment of the apex court applies in your case.
Then they will put behind the bar.
No, they will not put you behind the bar. There is a law. There is a judgment of the court.
Some protection will be given,
What protection?
but they may not be arrested. On such application, my lord, they may be allowed to go.
Accordingly,
If they are agree to take the time.
the apex court in the case of Siddharth versus so and so has clearly laid down the law that mere appearance before the competent court on summons being received would not entail detention of the accused persons. So the competent court is required to adjudicate appropriately any such applications that may be preferred by the accused persons before directing them to be taken into custody. Also, accordingly, this AV petition stands disposed of. The petitioners are permitted to appear before the court below competent court, which is JMFC Corbetta, and file appropriate applications. Post of this court, the competent court will thereafter decide the matter on its own merit and pass appropriate orders, taking note of the law laid down by the apex court in Siddharth versus so and so. Also, these applications may be preferred by the petitioners within a period of 1 week from today. Which is 19th, by 19th, 6. Also, if any such application is directed or filed by the petitioners by 19/6, the same shall be disposed of by the competent court by in terms of the law laid down, taking note of the law laid down by the apex court in so and so versus so and so and others. Till 19th, the no coercive action will be taken against the petitioners. Disposed. You will appear, you will file, and the court will pass appropriate orders. Until 19, no coercive action. Your outer limit to file is on 19th, 1 week.
They may not file tomorrow.
It's up to them. Outer limit is 19th. All right.
Of like
Item 42. 42 is the not.
City was called for. In this allegation, against the.
CD not received, when will you get it?
Support.
Chapor. After 1 week. Call for CD along with the injury report after. On 20, list on 20, 20. Right.
43.
Yes,
In this matter, they were called for FIR page 9.
CD
CD received.
is 9. Yes,
Yes, it is big logic, but the neighbor logic, it is not for the brother.
what is there in the CD?
The risk is the fight between neighbors. But the injury report shows that my lord, injury is dangerous to life. And as so far the petitioner number 1 is concerned, my lord, it seems from the statement of witnesses. He only tried to stop the fight.
Who tried to stop?
Petitioner number 1. He do not.
Fight was between whom?
My lord, the informant and Truvana, then my lord, the petitioner number 1 also came.
Yes. Who is the complainant? Here it is written. Dimbes Nath is also shown as a complaint.
Business is the husband of the.
No, Dimbes. The heart, Mr. Departmental Counsel is fully partners. Yes. The petition is filed by the petitioner. Praying for anticipatory bail, financial bail. So and so case number. Don't know EPS case number, so and so. It is alleged in the FIR dated 6/5/2023, lodged by the informant that his neighbor, that her neighbors, namely the petitioners, had assaulted her seriously, assaulted her with doubt, causing her inflicting serious injuries on the hand and the chest. Most of the dispute arose because of a land dispute. The assault was because of a land dispute between the petitioners and the informant. Where apprehending arrest in present heavy petition has been filed by the petitioners. This court by earlier order dated so and so called for the case diary. Case diary called for has been perused, and it is seen that from the statements made by the witnesses that there was a long-standing land dispute between the petitioners and the informant also. The injuries sustained have been shown to be not simple, have not been described to be simple injuries. However, considering the extent of the dispute as reflected from the case diary, this court is of the view that custodial detention of the petitioners at this stage of investigation would not be necessary provided they cooperate with the investigation. Also, accordingly, this court directs that in the event of the arrest in connection with so and so case, they shall be released on furnishing a bail bond of rupees 30,000 with one local security or like amount subject to the following conditions. They shall appear within 7 days from today before the IU. They shall not hamper or tamper or move out of the or attempt to influence any person or move out of the jurisdiction of so and so police station without written permission of the court. If any of the conditions are found to be violated, IU is at liberty to pray for recall or cancellation of the bail. If the petition stands allowed, disposed of, case diary returned. Online.
44.
38 application. Have had paid treatment. It's not involved this will be 6 minor. The petitioner before lordship minor, there is no allegation against him minor. There are 2 petitioner minor. All allegation against petitioner number 1, minor 20-year-old boy. My son minor, he eloped with a girl, he is 22-year-old minor. They are minor, eloped on there now, they are living as a husband and wife in Madras minor. So we have no connection with him, my lord. In time, the other minor police, after me, my lord, I went to the police station and give him address also here where he's staying in Madras minor. But they say that within 7 days you produce him, otherwise you will be. That's why I'm before your lordship.
Who is petitioner number 2?
Petitioner number my another son, my lord. I think rather the petitioner number 1. I mean the number 1.
Not named in the FIR.
No, not in.
So why is he apprehending?
Apprehending my lord, and their family, my lord. They call me to the police station. Either you produce him before the police station. I in para 4 I have to do.
Yes. Mr. EPP.
Well, here the allegation is against one Nurul Hassan, by
Nurul Hassan. Person named in the FIR is different.
Yes, ma'am.
The Roman Rama.
Roman Rama.
Roman Rama, I am not dependent on Roman Rama. He is my son, my lord. I love my lord.
Madam, Nurul Hasan allies Roman.
Roman.
Roman, madam.
So they have a love affair, but they look fine.
Has the girl been recovered?
Not the government.
How old is the girl?
22 years old. There is effect in the affair.
Heard, learned,
Madam, otherwise the witnesses were saying that madam, the person who gave a girl. Introduced himself to be a person from different religion, like then entice the government. And they are saying that these persons are also Mohibul Haq. He is also involved.
heard, learned counsel for the senior counsel for the petitioner, assisted by Mr. Swanson. This EV petition is filed by the petitioners. Apprehending arrest in connection with an FIR dated 18/5/2023 lodged by the informant. So the informant alleged that the accused persons named in accused person number 1 named in the FIR had enticed and kidnapped her daughter, was selling in women trafficking. Also, till the time of filing the FIR, the daughter was not traced, and accordingly, the FIR was lodged, requesting for investigations in the matter. Full stop. Petitioner number, the petitioner number 1 is also named as accused person number 2. Petitioner number 2 is another son of the petitioner number 1. And is not a named accused. Full stop. Learned counsel, senior counsel for the petitioner submits that both the boy and the girl have developed an intimacy as is reflected in the FIR, and at present they have married each other and are resident of Chennai.
They are now they are elopement, they are staying in Chennai, but I got the information. That information I have furnished to police.
Is there any difficulty in recording that statement in the order?
My lord.
Any difficulty if you record it,
My
that as per your information,
Yes,
as per the information received by the petitioner number 1, the boy and the girl are presently residing in Chennai after having married each other, after getting married. Full stop. Learned counsel for the petitioner submits that she
so
is.
I do not know, madam. Whether they have documenting made or not, my lord, they elope and staying in there.
We are recording as per instructions.
But my lord, my assumption that they are elope and they are living in the husband and wife in Chennai.
So husband and wife will have to be after marriage only.
I don't, that I don't know, my lord, without marriage or not.
No, then they are not husband and wife. If it is husband and wife, then they are bound to be married.
Yes, living relation, my lord, nowadays.
Yes. That is in the nature.
Yes, my lord, in fact, they posted in Instagram, they are living in the husband and wife, my lord.
So
I have, that information also I have furnished to my lord.
all these informations have been furnished to the, all the information as to the knowledge of the petitioner have been as regards the whereabouts of his elder son, who is named as the accused number 1 in the FIR, and the daughter of the informant have been furnished to the IU.
That aspect is not reflected in the C.
Which aspect?
Because they have parties the information.
That is his submission we are recording. And at this court, by the order dated 6/2023 had called for the CD. Learned APP submits that the matter is under investigation, and as on date, the girl has not yet been recovered. Also, at this stage of the investigation, no specific materials are available in the CD in respect of petitioner number 1 and 2, petitioner 1 and 2. Post of the post of the learned APP submits that the matter is still under investigation and matter is still under investigation. Post of we'll give you an interim today.
Give me interim, I he declared that
Here.
our statement will be recorded and I will. my lord-
Accordingly, at this stage, after the perusal of the CD, this court is of the view that at this stage of investigation, petitioners can be granted an interim bail. As such, if they are arrested in connection with so case number Lockheed Police Station case number 169 of 2023 under section so, they shall be released on furnishing an interim bail of rupees 30,000 each with 1 rupee security of life amount, subject to the following conditions. They shall appear before the IU within 7 days from today. They shall not hamper or tamper with any evidence. They shall not influence any person or intimidate any witness, and they shall not move out from the jurisdiction of the people PS without written permission of the IU. Let the updated CD be produced on the next date. Fixed on 21st of August. At least according.
Then hearing item number 59.
Yes.
Number 14 is the particular. Okay. I on page 722,
Page number?
41.
Yes.
I by one Munishwar. Saying that on 7/7, but his sister-in-law was kidnapped by the accused. It is also alleged that earlier also, the victim girl was kidnapped by the accused person, and with the help of police, they recovered the victim girl. Is the allegation. Now, like, can you note down the date of 7/7/22, he was kidnapped. And when earlier affair, page number 21.
21.
21.
Yes.
The acoustic one, Ainal. Single leg. He was the victim, said same victim was kidnapped by the accused person on 16/2/22. In that case, the said Ainal was arrested. He was he is the son of the present petitioner. Ainal is the son of the present petitioner. What happened, my lord? The victim and Ainal had love case developed. Thereafter, the first case was filed by the mother. He was arrested and subsequently he was released on bail on 13/7. During his custody of Ainal, the victim again missing from the house of another person. He was brought to the another village by the parents of the victim and put him in another house to sleep. On that place, he was missing. Now, this petition has been filed against the father of said Ainal.
this person called Ainal is in custody.
Now he is there. Now he is.
When was he released?
Released on 13/7, that's page number 24 of the order.
13/7.
13/7.
Yes,
But yes, if you receive, whether it is not up to date, last updated matter on 5/9/2022. On last occasion, your officer has directed us to take instruction whether that can be recovered or not. Today, over 4 minutes, before 10 minutes, that has to be recovered.
you have not prayed for cancellation of the bail of the person.
I know.
He's facing trial now.
This allegation is against my lord, this, that's it.
Array,
Option, father of fine.
but is he named in the FIR?
That's it, my lord.
Huh?
Yes, yes, yes.
His name.
Police suspect. They have said that earlier also this accused person has taken the victim back, but in the first affair, it is against only on Aina, the son of the president.
What is the status of that particular case? Charge sheet file.
But then I.
Earlier matter.
That was pending. Early June.
You get updated CD.
Yeah.
How soon can you get it? Get it within 1 week. We'll fix on 19th. Get it 19th. Let the updated CD as pray for before by the DPP.
There is an interim order. That's it.
Fixed on 19th. Interim. Maybe granted earlier, we got it.
Can it be taken later?
Tell us a date.
26 or 27 of this. Or particle.
19th of July. Interim bail granted earlier, we continue until next week. 19 July.
Item 60.
Which was also one of the election management. And it is considered submitted in this. And after your motion, what I actually for IO file, my statement has been recorded.
Charge sheet submitted now. After your appearance.
Yes,
Charge sheet submitted.
submitted.
So we close it.
Yes, ma'am.
It is submitted by learned deputy, Mr. R. Kaushik, that charge sheet by the charge sheet number
Well, 79 of 2023.
79 of the 23.
79 will be 23 dated
24. 204.
20/2004/2023. Accordingly, this AV petition stands closed. The petitioner, one petitioner
Yes.
will appear before the competent board before which the charge sheet has been filed and may file application seeking making appropriate prayers if so advised. Most of if any such application is filed, the competent board will take note of the law laid down by the apex court in Siddharth versus so and so and others and pass appropriate orders in the matter. The AV petition accordingly stands closed. The benefit of interim order, benefit of interim bail granted by the order dated 11/4/2023 is extended for a further period of 1 week. 1 week from the disposed.
61.
Please, your worship. This 438 bail application worksheet. FR is page number 81.
What happened to the habeas corpus? What happened?
Lordship, pending lordship, next one 16 lordship.
16. Then
Interim lordship. Directly economy is suspected to be involved.
we just get of the case has been as part of CID looks it. According to the case study of the murder case that has been sent to CID case that would do. It is going to wait for some time to put in the case.
Directed to be lordship, inquiry with DGP and IG. Another investigation was directed to DGP and IG lordship. We inquiry into the matter.
It is submitted by the London APP that the case in the meantime has been
I also not
handed over to the CID. Accordingly, he seeks a little further time to complete his instructions in respect of the investigations carried on. Let the matter be listed again on
16 lordship.
not 16, let it be on 21st June. On which date the London APP will produce the case diary and
Habeas
update the court. Then we'll,
Habeas corpus petition.
therefore it is fixed after the writ petition 21. List on so and so dates. Mr. So and so Leonard counsel appears for the petition.
62,
21st.
item 62.
CD along with internal report.
Case diary not before.
What he wanted 19th. 19th. Not what he.
Minor.
Leonard APP submits that CD along with case diary, the internal report as called for has not been received. He prays for further time. Your Mr. Ahmed, Mr. A.K. Ahmed, Leonard counsel petitioner submits that since no interim bail is granted and a short date will be fixed. Accordingly, list on 19/06, enabling the Leonard APP to call for the CD.
63,
Case diary was called for.
Case diary along with
Case diary not.
shut down 19th.
My lord.
Same order fixed on 19th. Call for CD along with the internal report.
64,
Along with the FSL report was called for lordship.
Yes,
That day when I paid for interim and it is lordship.
yes,
There's to
CD,
No, we have not received that case diary.
the real allegation only my lord can be seen. It's some sort of protection, my lord, allegation, no specific allegation.
fake currency, you'll have to wait.
My lord,
Yeah, when can you get it? No, now,
no,
20,
My lord.
my lord, 16, my lord, another Olympic pending lordship that is fixed.
16,
Number 2027 of 2020. 2027. Of 2020. On 16.
16, list on 16 as it is submitted that bail application. Other bail application arising from the same FIR is fixed. Accordingly, list along with AB number
2027.
2027 of 2023. 23, 16.
on orders, item 45,
Sorry,
Actually, kindly go to the.
You have not taken steps for implement. You have not taken steps for implement. You file an application for implement,
Right.
respondent two.
My respondent was important.
Learned counsel appearing for the petitioner, praise forward is granted 2 weeks further time to file appropriate application seeking implement of respondent, implement of whom the informant as a respondent in the present criminal petition. In terms of the orders of this court by the order dated 3/10/2019. Matter be listed after 2 weeks.
Right.
46.
Yes,
Stone is defined for washing of the complaint petition filed under PPA.
why is it listed for orders?
Should be listed for hearing, you already admitted for the last.
Scan copy received.
Yes.
As scan copy is received, let the matter be listed for admission. After a week. After a week,
Already admitted.
Huh?
Already
admitted.
But on the last occasion, Lordship, the
Ah.
honorable court was pleased to take the matter for hearing, Lordship. Admission, yes. Admission after 1 week.
No, it is admitted, then where is the question of admission? Yes, it is admitted. Matter be listed for hearing
Yes, Lordship.
in usual course.
Yes. No, date may be, trial is going on.
It is admitted,
I know. Date may be,
no date. Will come in the regular hearing list.
otherwise it will be in that.
Let it be in July. July 27th.
I know.
47.
And either. Said in as per office noted dated vacancy 2020 service not office.
Await service on respondent 2 to 11. As per office note dated 7/6/2023. List after 2 weeks.
48.
Services of property.
Service on respondent 1 is not complete as per office note dated 18/5/2023. Await service report. List after 2 weeks. Interim order. Interim order dated 1/3/2023. We continue.
49.
And for restaurant, but you could have had local.
MS
POD.
POD Gary, Learned Counsel, has entered appearance on behalf of respondent number 2. Scan copy, I said. Scan copy call for has not been received. Registry to issue reminders. List again on 27 July. Mr. Azad. Azad appears for the petition. Mr. B. Sharma appears for the states. Interim order dated 25/5/23 will continue.
There are the direction state is set for Brazil. Only the API responsibility, then need to file whether API or not.
All right, not necessarily. We need not clarify.
Yes, only the API.
We have permitted you to take dusty. They have appeared. Doesn't require clarification.
Item 54,
Yes.
That's okay. That's fair, it is there is so deeply in everything. Just a lot, only on the point of alternative remedy. Then oppose this equity. Okay, my first argument.
Before my friends start talking. Though initially we have accepted that the alternative remedy is there. Since 2020, like I said, so if the lordship allows him to again to find out alternative remedy, then it will be delayed. So lordship, there I have taken some judgment there, some kind of judgment are there, which says that when there is the procedure has not been followed, then the even I think lordship benefited from the point in this procedure. So that may be lordship. It is like it's a benefit.
Where is the, show us again the factual aspect, where?
Yes, but at page 30 is a Stoker's notice. Initial Stoker at page 30.
Then,
At page 30. Okay.
then,
If you lordship, is the Stoker's notice.
no, we'll see that. Yeah, against the show cause you file reply.
Reply at page 32.
Yes.
But I wanted to point out that because he has raised this plea, so I wanted to point out something.
What is that?
In exercise of power conferred by government notification dated so and so, the undersigned hereby acts due to show cause under Rule 9 of the Assam Disciplinary Rule, why any penalties prescribed in clause 1 to 3 of Rule 7 of the aforesaid rule could not be inflicted on you on the following charges based on statement of allegation. Now, the show cause is for penalties of 1 to 3.
Which does not include termination,
Does not, it's 7.
and subsequently you have been terminated.
Yes. Therefore, for inflicting with the punishment of termination, there is even no show cause.
Okay.
Therefore, the plea that it has been started, it can be reinitiated from the point. It is not. Lordship, therefore, lordship may set aside this in order and give them liberty to, if so advised, taken testing in case. But it is absolutely illegal, therefore. I may be reinstated, there is a prayer of.
Commissioner of the weak state, at least they have not.
So what we see if the termination order inquiry is interfered with,
Yes,
what is he supposed to
yes,
do?
at least from the point where the DP.
No, correct, from the, let us take your argument that from the point.
Yeah.
But the termination post the disciplinary proceeding, if it is interfered with,
Yeah.
what is the ground of not allowing him to join?
There is some. National lordship. If it's take the honorable, not lordship, there is no provision for directing reinstatement of the itself.
Reinstatement is a, you see, this person was working in a job.
Not.
You choose to proceed against him, this is departmental proceeding. Those proceedings ultimately, if the court comes to a finding that these proceedings are bad,
No. No.
what will you do now? You have terminated him, he is not under suspension,
No.
you've terminated him.
That,
So then you'll have to deem that he's under suspension and pay him subsistence allowance.
you are not facing, not in suspension, that's correct.
Correct. So now if the disciplinary proceedings have to be bad, consequential termination will go. Yes.
From 6.1.
Yes.
May I read that? 6.1.
Read.
At this stage, a recent decision of this court in the case of Pradeep Singh Pittas, in which the court has considered its earlier decision in the case of Prince Soros, is required to be referred to. In paragraph 15, it is observed and held as under. Paragraph 15. It appears from order passed by the tribunal that the tribunal also observed that the inquiry proceedings were against the principles of national justice, inasmuch as documents mentioned in the charge sheet were not at all supplied to the delinquent officer. As per the settled proposition of law, in a case where it is found that the inquiry is not
No,
conducted.
I understand that, but what happens to this man? How will he survive? When you're when the very basis of terminating him is taken away.
In the, that has been answered in the subpara,
Uh,
paragraph 16,
uh,
subpara. It is settled legal proposition that once the court sets aside an order of punishment on the ground that the inquiry was not properly conducted, the court cannot reinstate the inquiry. It must limit the case concerned to the disciplinary authority for it to
no,
conduct.
that particular paragraph itself is not enough. You will have to distinguish the facts of this case. This is a case where the inquiry report was not given. ECI.
Tomorrow I will.
Again tomorrow, what is this? We have given you enough time.
Yes, sir. And
What is this tomorrow business?
And moreover, this is a case where there is some lapses in the departmental proceeding.
that's why I said that.
There is no departmental proceeding in this.
Why do you say no departmental proceeding? Why no departmental proceeding?
No decision, the authority to if they are even though so-called for the punishment.
There are two things to say. One is to say that no DP was at all initiated against you, number one. The other is alternatively, the DP was initiated, but it was not conducted as per the rules. Which is your argument?
In my case, there was a show cause and a reply.
Exactly. According to you, the show cause was for imposition of punishment under clauses 1 to 3 or 1 to 7.
1 to 3.
1 to 3. But ultimately, they imposed the punishment of termination.
Yes.
So,
Therefore,
is it enough to say that there was no DP at all?
yes, but rule 9, there is a procedure for conducting DP. Rule 9 was not followed.
What did you say in your reply?
Reply of it was absent for 6 years. Not only that, okay. Come to the
What is your reply?
reply will not be. Paragraph 5.
Reply.
Paragraph, yes, reply. My paragraph.
No. Reply to the show cause notice.
So, reply to the super notice.
Yes, page 13.
Hmm.
Page 13.
Where did you raise this issue that the provisions of where have you raised this issue that the procedure laid down is not being followed?
Yes, sir. In my pleadings, sir. In my pleadings, at para 11,
What is the procedure not followed?
rule 9, rule 9, take up.
Service. Menu. Service menu. No, I'm not.
Okay.
Yes,
My book is 433,
on the rule 9, yes.
rule 9. Without prejudice to the provision of public servant inquiry Act, 1950. No order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after an inquiry had as may be in the manner hereinafter provided. The disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges together with the statement of allegation on which they are based shall be communicated in writing to the government servant and she shall be required to submit in such as may be specified by the disciplinary authority. A written statement of his defense and also state whether he desires to be heard in bench. At the time of delivery of the disciplinary authority can invariably furnish the government servant a list of documents and witness by which this article of charge is proposed to be sustained. Explanation in the subgroup 3, the expression disciplinary authority shall include authority competent under this rule to impose upon the government servant any of the penalties specified in Rule 7. The government servant shall, for the purpose of preparing its defense, be permitted to inspect and extract from such official record on as he may specify, provided that such permission may be refused if for reasons to be recorded in writing in opinion of the disciplinary authority, such records are not relevant for the purpose or it is against the public interest to allow him to hear to provide it. When a government servant is permitted to inspect or take
Mr. Tovilda, you are for the college
Department.
department. Anyone? Mr. Counsel, you are for the college. Okay.
May I submit one? Case 34, to the reply. The reply to the so-called notice, it is clearly stated that, sorry, or our order notice, case 34. In his reply, he never stated the reason why he was absent for 6 years. Neither medical documents, nothing. In our order, we have clearly stated that. See that case 34, 92 order. In the paragraph, you see 6 from the proposal. Okay, got it.
Yes.
It's the so-called reply is silent on which absence from 2011 to 2017 for 6 years. Even Lordship, I got the record also in newspapers also. Everything was published. He was asked to report to the college. He never reported. Neither he submitted any medical book. On that basis, Lordship was.
Okay. You may have very good reasons for removal,
No,
but there is a procedure prescribed
there is
and you have adopted that procedure. It is the college who has accepted that under discipline and appeal rules. So if you accept the discipline and appeal rules, if you say that the procedure is under discipline and appeal rules, then the procedure prescribed will have to be followed.
there is
Then
maybe that inquiry may be on that point first. That's a number does not say that in the twice Lordship he was directed to be stated in that document in this paper. So thereafter Honorable Supreme Court said paragraph 6.2 also in this case twice he was
you all right. We'll close the hearing. You give a short synopsis, not synopsis, not written argument. You just give your bullet points with the arguments which you have and the judgments you are relying. Do it by day after tomorrow.
yeah.
Yes, both parties. Day after tomorrow. By day after tomorrow, within 2 days. Yes. You can do it today, you can do it tomorrow, but latest by day after tomorrow. Hard result.
Item 65, supplementary.
Yes.
Wait. This matter was heard by a long time with regard to the sea cover procedure adopted by the Congress. With regard,
Then they were called as witnesses and therefore
yes,
It was put on the same cover.
Yes, actually, there was a, they have given a prosecution sanction to both the petitions, which was sought for by the, that was sought for by the CBI. Thereafter, that later came, that was sought for here, we did not give. Later on, they have filed an affidavit saying that there was a sought, the prosecution sanction was given, but subsequent thereto, charge sheet was filed, but we were not made any party in this, not made an accused in the charge. And then it was proceeded, we were made PW 20 and PW 21. In thereafter, your lordship, the criminal case proceeded accordingly, we gave our evidence, our witnesses as PW 20 and 21. And in the other hand, your lordship, they have admitted that departmental proceeding was not held, no charge sheet was filed against. So there was nothing against it. Therefore, the promotion she kept on the seat of is not correct. It is incorrect. There are two judgments that I have referred on that thing. One is Ankira, that is logical older judgment, and then in that is the 91 judgment, and then I have given a 2013 judgment, which is from our High Court, that is Anil Kumar Sarkar. Both I think is there as they have provided copy.
Yes, yes, it is here.
So in these two judgments, your lordship, basically, I refer to the, I don't know whether your lordship will remember. This is basically the whole case. Now, your lordship, just for the point with regard to what they have given. They have filed the affidavit. If your lordship will take up the affidavit for a moment, their affidavit. At page 139, para 6. Para 6 at page 139.
Yes.
I'll just read this paragraph. That your deponent begs to state that no departmental proceeding was initiated against the petition. It may be mentioned that the political vigilance cell department has furnished the CBI report by letter number so and so, and prosecution sanction was issued against the petitioners on 30/10/2015. However, no information has been received from the political vigilance cell department CBI authority about the criminal proceeding pending against the petitioner as on date, and hence the present status of the case is not available to the department. But we have annexed the charge sheet. We have annexed the charge sheet in our rate petition. The charge sheet, nothing has been stated against us, right? That you are going to find. I'll just point out the
Assess. Yes, please.
what you will find, just in my read petition, we'll just point out the actual of the facts and just point out the relevant part of the record. So at page 23, annexure B is the FIR of my report. Just go through it, just because nothing much to argue now. But page 23, annexure B.
Yes.
Here I will just point out your lordship. This is the FIR. Lordship may see the FIR number, that is RC 0172013 A0001, because that is the relevant, because the lordship was confused whether in this case or in some other case I am required. So this is the FIR. In the FIR, your lordship, we are not named. It was a short FIR which was which is at page 26.
Yes.
Some other person named were there in the FIR, that is at page 26. It was registered under 120, 420, 468, 471, 477. 26 is the FIR issued to the head bench CIP by the person concerned who made the written complaint. This is the written complaint. Here your lordship, I am not reading the written complaint. Here the name of two persons were stated. That is the president and secretary of teacher government. In connivance with master counsel of our. This is basically the case. Now your lordship will see at page 30. 30.
Yes.
This is by the CBI to the special judge. Here your lordship will be in the subject column, the subject paragraph. CBI ACP Guwahati branch case number. This is the case. So it is the same FIR. So against that, these are the persons whose names are given to the special judge. Here, your lordship, our name is also
Not referred, not mentioned.
not. Then your lordship will kindly turn to the charge sheet at page 32. This is the charge sheet of the CBI. Page 32. Page 32, this is the charge sheet of the CBI. Here, your lordship, accused were named from serial number 11 as A1, A2, A3, A4, A5, A6, A7, A8, A9. With this A9, the two petitioners' names are known. So in this charge sheet, they were not named. So initially, their prosecution sanction was given, but they were not named in the charge sheet. So that goes your lordship. Then your lordship.
No supplementary charge sheet also later.
No, there was no. Then your lordship kindly turn to page 47. Page 47 is the order of sanction, prosecution sanction. Here, your lordship, they have given prosecution sanction, and this was on the basis of the letter that was issued, which we could not annex. It was annexed by the in the affidavit, your lordship. Here, your lordship will find the letter under which the prosecution sanction was given. This is your lordship will find at page 144 in the affidavit in opposition by the respondent. So there was a letter for prosecution sanction that is now admitted, and therefore prosecution sanction was given, but we were not charged with it, and neither there was any disciplinary proceeding.
Where is that letter?
Letter is 144 of the affidavit in opposition. I think it is clearly given 144.
25th of June.
25th June 2015. This is by the vigilance cell with the secretary Dr. Assam Panchayat. In inviting reference to this department's letter on the subject cited above, I am directed to request you kindly to furnish the prosecution sanction in respect of Sri Rupa Bharali, so and Sri Sanjeev Das, who report block and sought for our earlier letter. This earlier letter was there, but subsequently again they have given this letter. Therefore, this sanction was given on 30th October 2015. But thereafter, your lordship, there is a CBI report which was annexed along with this letter, which they have also annexed, that your lordship will find at page 149. I'm taking your lordship to that because
It was initially initiated through the vigilance cell, then handed over to CBI.
so 149 for yeah, along with that letter. This is the CBI report 149. I'm just showing the case number, the same case. That is RC 0172013800001. So this is basically the matter you want. And they have admitted in their affidavit that they have not taken any no departmental proceedings were initiated against you. And with regard to the seal cover that they have annexed at the page 250, 215. I'm not reading all the annexes and documents because the relevancy is not there. So straight away I'm taking your lordship to 215. 215 is the recommendation of junior engineer to the post of assistant engineer. The same affidavit they have filed. They have indicated that it was seal cover, prosecution sanction and insufficient issue. First one, Rupa Bharali, serial number 1, seal cover, prosecution sanction and insufficient case. This was the remarks.
2-1,
What is 215?
2-1-5.
215, 215.
Yes.
215 serial number 1. Rupa Bharani is the petitioner number 1.
Okay.
This is the recommendation where it has been in the remarks column, it is shown as seal cover prosecution. And the other is Sanjeev Kumar Das, that is a 218. Here, your lordship, I think nothing in the remarks column, but I think that seal cover should have been in 88. They have typed it in 89, maybe, I'm not sure. Nothing is in the remarks column. With regard to something. Is 88, serial number 88. So 1 and 88 are the-
Assuming this remark is for 88,
yes.
it lists two reasons. Number one is departmental
Departmental
procedure and
proceedings and
insufficient.
insufficient. So neither there is departmental proceeding, insufficient ACR part, I'd like to make a little bit of submission. If there is something insufficient in the ACR, it is not the petitioner who is to be blamed. They will provide the authorities, higher authorities, who are, they are supposed to provide it, maybe they have not provided because of some, whatever reason, they can always call for. This is basically the case here. So in view of the judgments, I have shown that there are no proceedings against us. And also I have annexed that we will meet the prosecution witness that page 77.
What is the stage of the case now? CBI,
That part I don't know. That I don't know because
Mr. Kumar?
No, that is absolutely.
because ultimately there are, I think, lots of PWs. I don't know what has happened. We are PW 20 and 20. I have annexed those.
The purpose why I'm asking you is, have you been made? Is there any order making them accused persons later?
Lordship, one thing, if we were made an accused person later,
During the course of the proceedings,
trial,
trial.
during the course of the trial, then your lordship, it will have a different, because again, they'll have to come back,
So
because we were
what
witnesses.
I'm thinking is perhaps the department was of the view that since they have requested for sanction, we have given them sanction. So the sanction has been given. Although you were not arraigned as an accused, not made as an accused person, trial did not proceed against you, were not named in the charge sheet. The department perhaps was of the view that we have given sanction. So sanction for prosecution.
But two things should be kept in mind. The sanction was given. Prosecution, they after giving the sanction, whatever has happened by the CBI, that was with regard to.
Subsequent, how many DPs were there?
If there is.
How many DPs were there? How many DPs were there? In how many DPs were your case considered?
I think there are two
2 DPs.
that we have annexed.
Now both of you have retired.
2020.
Both of you have retired.
No, the first one has been. Petitioner number 1 retired, petitioner number 2 is still in service.
He's still not been promoted.
No. This pendency of the case, your lordship is there, and therefore he's stuck. And I think the petitioner number 1 retired on 36/2021. It's long time. About yes, about 2 years.
What is the stage of the proceedings?
So far as the is concerned, we have no instruction.
No, the reason I'm asking you is because you are the employer, you are given a sanction against your employees.
Sanction was sought for before filing charge sheet. The report was
produced to the concerned authority by the agency or
Your
investigative agency.
your duty as an employer doesn't end there. They're still your employees.
Yes.
Now, if you have given sanction, in the subsequent DPs, you should have evaluated what is the stage.
Depending on
My lord, the evidence part is over, my lord, and the case is fixed for 15/6/2023 for final hearing.
No, but are they arrayed as accused persons there? Are they? Huh?
That, section.
Because if the evidence is over, we have given our evidence, both the Varali and Sanjeev Kumar Das.
Thereafter, no summons.
Thereafter, nothing is there, because if something would have been there, we would have been called, your lordship. That is why. And since the already evidence is over and it is for final argument. And my part is, your lordship, with regard to my promotion. With regard to Dhruva Varali, that also I will be getting on the, your lordship, monetary benefit, nothing else. The other person, obviously, he might get full benefit. But he will get one promotion because he was a little bit in the, I think at serial number 8. Dhruva Varali otherwise would have been getting 2 promotions. That they will always see and decide in.
you are not the so far as Sanjeev Das is concerned. Different person. Different person.
No, sorry, we didn't hear you.
Yes, your lordship. The name appeared in the serial number 88, your lordship, at page number 218. Sanjeev Kumar Das. And the lead petitioner Sanjeev Das, 2 different persons.
On what basis you say that?
Your lordship, from the instruction itself. Your lordship, the instruction says this. Sanjeev Das, junior engineer, Rani Development Block, Kamlo, the second petitioner has not submitted his ACRs and APR. Therefore, his name was not kept in Silkovar as per decision of the selection board and no promotion was offered accordingly. So he failed to submit APR.
And this person at page 218 is a different person.
Because if his name was not recommended, so then your lordship.
It is for your clients to say whether
He
this
has not
person.
stated that in the evidence.
Your lordship, kindly see page number 140, paragraph 8, you will. 140. Our 140, paragraph 8, you will. Your department begs to state that as per minutes of the departmental selection board meeting held on 22/2/2021, the decision of the departmental selection board in respect of promotion to Sri Varali, that is petitioner number 1, he then junior engineer, Sapatari Development Block, Bongaigaon was kept in Silkovar for pendency of prosecution sanction and insufficient ACR. But petitioner number 2, Sri Sanjeev Das, junior engineer, Rani Development Block, had not submitted his ACRs and APR. Therefore, his name was not kept in Silkovar as per decision of the selection board and no promotion was offered accordingly.
Then that will be a different type of, because then there is nothing to do with prosecution cycle in this case. So if it is not kept in Silkovar, then it is fine.
Then why has it not been,
Then we should have improved.
why has it not been considered?
Considered because APR was not submitted by APR.
What is APR?
Annual property report.
Property.
Property.
And his ACR has not been submitted, is not his fault.
No, ACR is not his fault. I don't know what is.
Why ACR is not submitted is because the officer concerned did not submit it, then it is not his fault.
No, it's possibly because he is not. May not be-
ACR, I cannot write my own ACR. It will be written by the either the authorities. And then they will submit it. APR part, you don't know whether that is
Yes,
required.
ACR, custodian of the ACR is different authority, but at the time of consideration by the DPC, the ACR ought to have been submitted by the officer himself, you know.
If not, it would have,
So
it
far
should
as
have been.
APR is concerned, that is entirely on him.
Whether APR is required for promotion. Your Lordship, it is considered on the basis of the case number 21.
That makes a different case altogether with regard to respondent number two. Now, petitioner number two. Petitioner number one is a clear. Petitioner number two in that case, your lord. They will consider accordingly and they should have intimated him that this is your APR is not been submitted. So kindly submit your APR for consideration of it. Normally that is the procedure. So who are under the zone of consider in a promotion are informed to produce the documents, whatever is required for if there is an interview, it is they are called for the interview. If it is for the other basis of ACR or the seniority from then that is considered. And if there is not something is not there, they are called for or they are called for by the department, basically by the DPC that the department kindly send the ACR of this. It is not in the record. And that is sent. APR part I don't know because that is something earlier I have never seen that in a promotion. APR is also required to be submitted.
Yes.
Your Lordship, the
So you hold the review PPC, consider their case, pass appropriate orders,
is so far as the
both. Both.
as a so far as the
Overall, number one is considered. Your lordship can always direct to reopen the seal cover and take a decision on that. Because if they reopen the seal cover, they will get the report of it and then they will take a call on that. Second one, if they are not
Yes.
in seal cover, then they can go for a fresh.
Your Lordship, the recommended these your Lordship, the petitioner numbers one names appear to be serial number one. Only thing is there, this result is getting super.
You reopen and take appropriate decision.
Then your Lordship, you have to produce before the authority. There is no case pending against you.
How will he produce?
It is for itself because he is the.
He can't produce. Why should you penalize him? You have given the sanction. You pursue it and say whether it is there or not. It is not there, it is not there.
The action was given on the report, on the basis of the report. Where
Correct, but they are not accused.
Yes, subsequently, the subsequent development is not with us. It
Correct.
may not be.
So does it mean that you will keep his papers in seal cover for eternity? He is a person, he is your employee.
Yeah.
Today you have found that in spite of the sanction being granted, they are not made an accused.
He not salved. Sasi was not filed.
Then they are not named as an accused.
Second, he's also retired, you know, long back, 2 years. He obviously is not getting, yes, he's obviously, I don't think he's getting. He's not even got his pension because.
The provision of public. Until the series completely.
I just point out the judgment you are because the two judgments, that is 1991 4 SCC 109. This is Union of India versus AB Janaki Raman. Paragraph I'll just refer. I'm not reading the paragraphs, the three paragraphs, 16, 17 and 18.
Yes.
So in these three paragraphs, you are both is very clear. That you cannot keep it in seal cover when there is no proceeding. So start with this. Look at three paragraphs, I can read these. Takes para 16. On the first question as to when the purpose of the seal cover procedure, disciplinary criminal proceedings can be saved and commenced. The full time to the tribunal held that it is only when a charge memo in a disciplinary proceeding or a charge sheet in a criminal prosecution is issued to an employee that it can be said that the department of proceeding criminal prosecution is initiated against him. The seal cover procedure is to be restored only after the charge memo charge sheet is issued. The pendency of the, in this case, your worship, both were not issued, even when they kept it itself. The pendency of preliminary
They
investigation.
kept it in seal cover in contemplation that charge sheet you'll be named as an accused because prosecution sanction has been taken. As simple as that. There, I don't think the department entirely can be faulted with because they were not aware of whether you are named as a charge sheet or not a charge sheet.
That we are not, but subsequently, your worship, when the charge sheet is filed and it has been brought before this honorable court, the department could have taken a stand on it to you.
Or the department, it is coming to the department's information, because at the time of.
Was it not pointed out before the department? The charge sheet was not filed. I mean, charge sheet, you were not named as an accused.
Yes, because we have given the pool, I think there were even 2 applications they filed by the petitioners. Possible fine, representative were filed. That is
Page number?
Page 92. Both the petitioners filed the representative. Page 92 is, I think, but over and the other is. Here both are similar, you know. First paragraph, second, fourth. Yes, fourth, your lordship will see. 3. That's the accused persons in the aforesaid were so and so, the names of the accused persons I have given. Para 3, para 4, that sir, during the said CBI inquiry, I was called as witness and before the honorable civil judge CBI Assam, so copy of summon letters and. That's due to the aforesaid case, although not being involved in the case, the prosecution sanction was listed against me, where so and so this is so is which have suffered irreparable losses in my career. That even after completing more than 30 years, I think.
Okay. So,
This was given by both of.
yes, Mr. Moore, anything else? Mr. Dr.
I'm willing to. It's in the effort to be clear also.
Record, you got some record.
Yeah, next year reports. It is the only basis of the report.
All right, heard. Reserve.
Lordship, the other judgment, if you lordship would like to refer, that is 2013. 4 SCC 161,
Anil Kumar.
Anil Kumar Sarkar.
Yes, it is.
Here I am referred to paragraph 14, 16, 17, 18, 19, 20, 20.
And the earlier judgment, 16.
In earlier judgment, 3 paragraphs, 16, 17, and 18.
Okay. Reserve. Disposed.
One more thing, Your Lordship, with regard to the second Sanjeev Kumar Das, he was also called as a witness. Here in the annexure, we have given only, though we have stated in our petition that he was also called for as witness number 20. But we could not annex that document. I have the copy of the.
It is mentioned in the representation also.
Yes, but if you have, Lordship want.
They are not disputing.
No, they are not disputing,
They are not
even in the second one. With that they are not.
They are saying that the person in serial 88 is a different person. Are you
Maybe,
seriously?
Your Lordship, because on the instruction, it appears that his name was not recorded.
No, but is it an inference or is it a specific instruction?
Your Lordship, my specific instruction is the Sanjeev Das, name of the Sanjeev Das was not recommended because he failed to produce ACR and APM. His name was not recommended. That is my specific.
But if his name is not recommended, then that list is a gradation list, isn't it?
That is the recommendation.
Recommendation.
Is the recommendation from junior engineer to.
But other persons whose names were recommended in seal covers, they are referred in that list.
Yes.
So why was he left out?
Your Lordship, the Superintendent Sanjeev Das failed to submit APR.
Where is that page number? One,
Page number
215.
215.
215. 15.
This is recommended junior engineers to the post of assistant.
215. Serial number 88.
50. Two 18 is serial number.
It's Sanjeev Kumar Das, the petitioner's name is Sanjeev Das.
No, see, if you come to 215.
Yes.
215 is recommended junior engineers to the post of assistant engineer.
Yes.
Both are junior engineers
Yes.
recommended to assistant engineers. I
Yes.
mean, they are claiming to be assistant engineers.
Yes.
Serial number 1 is technically not recommended because his files are put under sea cover.
Why I am saying that, your lordship, let's list out one thing, kindly go to page 210 for a 210.
Yes,
This is also, your lordship, it starts from page 206. It
Hmm.
starts from page 206, flag 8, they have given. Kindly take 206 for a moment first.
yes.
Why I am saying that? Because this is the list of selected junior engineers for promotion to the post of Western India under the so and so and so. Here number 1 is governor, that is their affidavit.
Hmm.
Here in the lordship will see PP.
Hmm.
Then your lordship will turn to 210. 166,
Yes.
Sanjeev Kumar Das,
Hmm.
prosecution sanction.
Hmm.
Here they say it is prosecution sanction. And Madhupur development block number.
Hmm.
This person was in Madhupur development block. Therefore, I said that it is the same person. I don't know, some other person in the same name and also been given prosecution sign. Is what I am not sure. But in the other Sanjeev Kumar Das, in page 218, there it's not written as it.
The data I have received from the secretary, it said that Sanjeev Das name. But not the one. It is not. Because it is not name is Sanjeev Das. Here the 88 serial number Sanjeev Kumar Das.
They may be correct, I am not sure, but but somehow or the other, both the Sanjeev Das and Sanjeev Kumar Das are having prosecution sign. That is also very unique.
Right. It is not to find them.
देखो लिखा ना
They don't do it.
हाँ কিন্তু এই জন্য তো সতীশ কুমার দাস
It is not the name of the.
हाँ, देखो সতীশ কুমার দাস সরি এটা কোন প্রসিকিউশন নেই था But that overall will not make any difference. What I have said that as per their affidavit, they said that he has not provided the ACR and APR.
All right.
That will take its own course.
All right, heard, reserved.
Comment.
Then